I think that's everyone who's announced themselves, but it looks like based off of what I'm seeing, Chris, we have more.
Okay, more folks?
It does, but they haven't spoken up yet.
Okay, then why don't I think at this point, why don't we go ahead and open it up for public comment? If there are any members of the public that would like to speak, why don't we do that now?
Mr. Chair, this is Mitch Winnick, the Dean of Monterey College of Law. I would like to speak for a minute when the time's appropriate.
Okay, Mitch, why don't you go ahead and speak right now?
Well, thank you very much, and thank you for the work this group is doing. I'm 100% in support of this whole concept. I see from your agenda you're going to go over in great detail both the previous studies on access to justice, the justice gap. I also see you're going to review and update what's going on in other states. So I won't take your time to go back over those issues. I would like to focus on just one specific thing that I would like to see added to the conversation. And the way I frame this is if we look at the medical model, you have doctors, physician's assistants, nurse practitioners. When you look at the legal model, you have lawyers, you have in Washington State, limited licensed legal technicians, then paralegals and legal document assistants. One of the differences in those two models is the medical model provides an alternative professional graduate degree that the legal model doesn't offer right now. The California accredited law schools offer the opportunity for this committee to consider whether that might be an option. The Master of Legal Studies could be easily adopted to provide a graduate legal degree as an option for either triple LTs or a different paraprofessional. I think there's a certain benefit that we've seen from the medical model where there's a licensed graduate professional degree that stands in between technicians and the MDs to be able to provide a very defined range of medical services. And I think that's similar to what you're going to be discussing today. So I would just leave it to ask you to also consider the option of not merely certificate programs, AA degrees and bachelor's degrees, but the possibility of taking advantage of the California accredited law schools that have 23 locations across California to consider a Master of Legal Studies as a possibility as well. Thank you.
Hey, Mitch, thank you very much. Are there any other speakers for public comment? Okay, hearing none, I would, now that I realize that Trustee Manning is on, I just wanted to see if there's anything that you might want to add to the conversation since you've been involved a little bit longer than I have on this, and welcome. Thank you for joining us this morning.
No, I don't have anything to add. I'm looking forward to the discussion now, and let's get started. Thank you.
Okay, so before I turn it over to Randy, I just want to say again that I'm really excited about this opportunity and the work that has been that the staff has put into this, looking at this opportunity for the state bar. It's something that I think, as I look at this, and I've seen the presentations from Washington, that there was already a huge need in the community prior to this pandemic, with the housing crisis and just the challenges on a lot of low-income families that I just see in my normal everyday work. So I think now with this pandemic and some of the things that we're seeing out in the community, I think this really presents itself as a potential opportunity to help thousands and thousands of folks. But I'm being biased. It's just kind of what I see on a daily basis. So with that, let's move to item B, business, where we'll have the overview of previous California efforts. And I believe that we turn it over to Randy and his team, correct?
Chris, before we turn it over to Randy and his team, we would just like to do a quick update on the working group charter, and then I can go through the roadmap. So the purpose of the working group charter, which was adopted at the March 2020 board meeting, was to develop recommendations for consideration to the Board of Trustees for the creation of a paraprofessional program to increase access to legal services in California. The charter includes that we'll be discussing the eligibility and licensing requirements, a regulatory model, the practice areas and tasks paraprofessionals will be permitted to perform, and then looking at the program as a whole, looking at the metrics that we can collect to evaluate the efficacy of the program and assess the effectiveness of the program. To do that, we'll be doing a series of meetings. We'll start with the preliminary discussion of the practice areas today. And then we will go into a discussion of the practice areas and tasks for the 2 summer meetings that we'll be having. After that, we'll go into the competencies for licensure and the pathways for licensure. It will probably be touching on some of the comments that the Dean of Monterey College of Law just made related to looking at the types of degrees and the pathways for which a paraprofessional could be licensed under this program. Then in December, we'll start discussions on the regulatory model, which will include metrics. And then moving on to the rules that we'll have to change or create to stand up the regulatory model, and then statutory changes, what we need to change in state statute to support a new model in the state of California. Finally, and before we present to the board, we'll be developing some sort of way of how we would think about increasing awareness. What we'll hear later on today, particularly when we're talking about the Justice Gap study, is that there's a lack of awareness of how to seek legal help in California. And so one of those items that we'll be talking about as part of this group is increasing awareness and the marketing of the program. And then we'll be developing the final recommendations for review. In between our working group meetings, there are a series of 3 board meetings, one of which we've already had, which developed the charter and created and adopted the composition of this working group. After that, which will happen in September, we'll present the concepts of the practice areas and tasks that we as a group decide to recommend to the board as just concepts in September. And then finally in July of 2021, we'll present the final report and recommendations. Do you guys have any questions on that framework of what we'll be doing as a group?
I have a comment.
Mm-hmm.
Can you hear me?
Yes, we can hear you, Julie.
Oh, thank you. There's one important issue that's not on this charter, but that I think should be the subject of some discussion and perhaps a recommendation. And that is where to house this regulatory program, should we decide to recommend one and should the board decide to adopt one. Where to house it? Do we house it in the state bar? Do we house it in the Department of Consumer Affairs, which is an executive branch agency that includes lots and lots of other occupational licensing boards? And if you read Mr. DeFentorum's memo, you know that the bar, this is not a new issue for the bar. This has been studied many, many, many times before. And on prior occasions, the recommendation has been to house this program within the Department of Consumer Affairs. So I just think that's an issue that we should discuss at some point and perhaps be the subject of a recommendation that's not on the charter.
Thank you, Julie. And I see a hand from Leah Wilson.
I was just going to say, I think that we can fit that nicely into the regulatory model portion of the working group charter and function. So we have a meeting dedicated to focusing on the regulatory model. I know on the staff and me as on the consultant side, we've certainly talked about options with respect to who the overarching regulatory body would be. And so we could make sure to bring that forward at that time.
Let's see. Amos is trying to call
Thanks, Ann.
it. I'll handle that.
Randy or team, do you want to go ahead and get started?
Sure. Good morning. This is Randall Diefentorm. Can you hear me?
Yes, thanks, Randy. Thank you.
I'm the director of the State Bar's Office of Professional Competence, and the Office of Professional Competence administers the State Bar's professional responsibility programs. The office also manages the mandatory fee arbitration and certified lawyer referral service programs. Among the professional responsibility activities are the Ethics Hotline Research Service for attorneys and the Standing Committee on Professional Responsibility and Conduct, known as COPRAC. COPRAC is the group that drafts State Bar's advisory ethics opinions, also conducts the annual statewide ethics symposium. And actually, I'm glad to see Iris Spiro, an alum, actually a Hall of Famer from COPRAC, among the working group. With me from the Office of Professional Competence is Andrew Tuff, supervising attorney, and Mimi Lee, senior program analyst. They will be making presentations this morning as well. I've described the office a little bit because I understand that professional competence will be a resource to this working group. We'll be available to assist you, especially on the topics of professional responsibility, unauthorized practice of law, and the Access through Innovation Legal Services Task Force, ADLS. Professional competence served as staff to ADLS, and as you know, the ADLS final report is part of your agenda for this morning. Before I go any further, are there any questions about the Office of Professional Competence or the staff? Okay, so let's turn to the past consideration by the State Bar of a paraprofessional program, and the materials is linked under B1 of your agenda. It's a memorandum dated January 23rd to the Board of Trustees. It was presented at the January Board Strategic Planning session earlier this year. And I'll mention that there is an archive of the live video stream of that planning session at the State Bar's website. If you wanted to view it, you can use the search function at the website to search for webcasts, plural, and I think the first hit will take you to the page with the archived videos. I won't repeat everything in that memorandum. Instead, I'll be offering some personal observation and highlight some key takeaways from this prior consideration of this initiative. And the starting point is the unauthorized practice of law. With limited exceptions, the practice of law in California is reserved to authorized persons, primarily licensees of the State Bar. This means that some form of express authorization is needed to permit other persons to practice law in California. An example, a recent example, would be the Military Spouses Program under Rule of Court 9.41.1. That program permits a lawyer licensed in another state, but not licensed in California, to practice law in California when their spouse is stationed in California. One of the oldest efforts, and what is towards the end of my memorandum, are the so-called treaties. These began back in the 1930s. These treaties were essentially interprofessional agreements between, at the national level, the ABA and national associations, and at the state level here in California, between the State Bar and various lay groups and associations. These agreements provided guidelines for the enforcement of UPL, unauthorized practice of law, in certain gray areas. For example, there was a 1965 treaty. This is with the Cal Land and Title Association, that prohibited title companies from giving legal advice, from appearing in court, but it expressly permitted the preparation of certain legal instruments, escrow orders, insurance title orders. It also allowed the giving of explanations to customers about these legal instruments. However, the treaty clearly prohibited other document preparation activities, such as the preparation of a will or living trust. These treaties remained in force for many years, but they were revoked around 1979 out of concerns that they wouldn't withstand Federal Trade Commission scrutiny for anti-competitive activity. But even after being revoked, these gray areas, from what I can tell, did not become any sort of problematic UPL issue. Now, it may not be remarkable to think in 2020 that insurance professionals could draft and execute escrow title insurance instruments, but that was a long time ago. The ABA's interprofessional agreement was from the 1930s. And I just offer the observation that maybe 90 years from now, it'll be taken as a given that non-lawyers could do such things as drafting modification of support. But that's just how the regulation of the profession evolves. The takeaway I want to offer from these treaties is that since you're talking about areas of law today, that's the focus, that it wasn't just the specific groups or areas that was addressed by the treaties. They were very specific. It was very contextual. And so it wasn't just, well, in this area of real estate law, you can do this. It was much more contextual. And so it will describe what is permitted, with whom, and will, because of closely related activities, it will say what is absolutely prohibited. And I think that's something that will inform the work going forward with this group. Now, if you fast forward to the 1980s and 1990s, you have the Public Protection Committee and the subsequent Commission on Legal Technicians. These board-appointed entities were given a stated objective of enhancing legal services, and they were the first groups to really look at this through the lens of the access to justice and the broader access to legal services concerns. Both of these groups found a great need for legal services options for consumers, and both of them endorsed the idea of allowing non-lawyer paraprofessionals to render some limited legal services. In fact, the Commission on Legal Technicians found that that activity was already occurring. Commission on Legal Technicians conducted surveys, surveyed public, surveyed providers. They invited representatives from the Washington Limited Practice Board to make presentations, and they ultimately adopted the concept of a pilot program, which made its way up to the board in 1991, and that's the actual draft rule of court that you see in the attachment to my memorandum. It was a pilot program that would have authorized, again, focusing on areas of law, non-courtroom legal services for landlord-tenant matters, and the recommendation contemplated oversight by the Department of Consumer Affairs and the formation of a dedicated regulatory committee composed of attorneys, paralegals, and public members. And this idea of regulatory oversight is also one of the main themes of the bar's past consideration. Now, even though you had the support of the Public Protection Committee, of the Commission on Legal Technicians, and later the Board Committee on Admissions and Competence, when it finally got to the board level in 1991, it was voted down. The vote, I think, was 16-4 as reported, and the vote occurred after a group of over 15 legal services advocates and so-called legal technicians all opposed it. Now, what I see as the problem back in that time period is that you didn't have certain things that you have today. There was no statutory definition of a traditional paralegal. There was no codification of what would be scrivener or typing service activities, the legal document assistance that we have today, the unlawful detainer assistance, immigration consultants to some extent, but none of these things were really in the landscape. And so what you had was the great distraction of overlapping regulatory interests from other stakeholder groups. For example, the Commission on Legal Technicians received input from traditional paralegals. The traditional paralegal advocates were saying, we don't want these legal technicians regulation to be confused with what we do. And in fact, they were advocating for even a more finer reform within their own stakeholder group. They were looking to distinguish between the paralegals who worked full-time for a single law office versus the paralegals who were so-called freelance and did contract for different offices. At the time, legal technicians really wasn't the vogue term. There was this discussion of paraprofessionals as independent paralegals, and that really disturbed them in terms of what they saw as their paraprofessional area. And you also had the scriveners or typing service providers, the self-help folks, the de facto legal technicians, arguing for to the Commission on Legal Technicians for grandfathering, or what we'd call grandparing at the time. But what entered the picture there was that there was no statutory definition of what a legal document assistant or lawful detainer assistant is. And so the professionals or paraprofessionals who were out there doing much more than self-help also wanted that same protection. And so the Commission on Legal Technicians found that there were non-lawyers, so-called independent paralegals, out there practicing family law, essentially. And with this regulation going forward, they were advocating for being protected. And so the distraction of the regulation of paralegals, the division between the concept of scrivener work or typing services, that it is not the unauthorized practice law. The case law makes clear that those types of self-help or general legal information or typing services are permitted, versus the de facto legal technicians that were already out there, made it very hard to focus on what is the focus of your working group, which is actually authorizing persons to practice limited practice of law. So you can fast forward from that time frame to the later activities of the 2013 Limited Licensing Working Group and the 2015 study. And these groups had the benefit of what was ultimately enacted at the legislative level in terms of a traditional definition of paralegal activity, the legal documents assistance and non-lawful detainer assistance. And with those on the books, you had the 2013 Limited Licensing Working Group and the 2015 Civil Justice Strategies Group able to focus on the narrow initiative, the concept of licensing unsupervised paraprofessionals to engage in some limited delivery of specified legal services. And the themes that you get from those groups, of course, you had the focus on legal services, but now you see emerging the idea of you really need the involvement of stakeholders. You need to have the Supreme Court on board, you need to have the legislature on board, you need to have the subject matter experts who know the area's law where there might be tasks authorized for non-lawyers as a voice in the process. And you need the access community involved as well. And this concept of working with stakeholders was even present in that 1991 rule of court. These provisions ultimately, if you look at the 2015 board action, led to another theme of this past consideration, which is you need to start small. And so the 2015 action would have restricted the initial implementation of the paraprofessional program to a single subject matter area, and would have sought early on in the process for designing the program the input of the California Supreme Court. And so all of these things become really the takeaways from this past consideration. You have the, and Russia, you can move to the next slide. You have the close coordination with regulatory stakeholders, especially the Supreme Court. UPL is codified in the Business and Professions Code. It can give rise to criminal penalties. give rise to assumption of jurisdiction, and those are all by statute, so you're going to need to work with the legislature. Supreme Court has plenary and primary authority over practice of law, so you have a lot of rules of court for special admissions activities, foreign legal consultants, certified law students. All of those things are rule of court based, so you have that aspect as well. The second bullet in the common themes, the goal of enhancing consumer options and access to legal services. Again, your focus this morning is on practice areas, and you'll have an opportunity to see from the most current access data what are the areas of greatest need, and even not just for indigents or those under 25% of the poverty level, but even all Californians in terms of what is needed. And that was similarly a focus going all the way back to the original Public Protection Committee and Commission on Legal Technicians. Third bullet, the common themes of the past consideration. You need to start with an initial program that implements a modest scope that can be monitored, evaluated, and expanded as appropriate. That was with regards to the 2015 board consideration. The idea being that you can set up the regulatory scheme with a single area, with a narrow scope, learn from the execution of it, and then expand it as appropriate. The early consideration of a bill that would have just provided for registration and very little regulatory oversight was opposed by the board-appointed body that looked at it, in large part because it felt that if you even were going to consider any sort of regulation, whether it's Department of Consumer Affairs, whether it was licensure or registration, that there had to be some sort of oversight and regulatory balance to what is authorized as what would otherwise be unauthorized practice. So that is another important theme of the past consideration. The last one, the establishment of the regulatory body, also present in the 1991 Rule of Court, the attachment to the memorandum. But a regulatory body, when it comes to practice areas, when the Adels Task Force looked at this, there was some discussion of the fact that a regulatory or oversight body, it might not need to have as a dedicated seat or member of that regulatory oversight body an actual subject matter expert in every single area of law that would be authorized for paraprofessionals, but that there might be one approach where you could have an advisory body to the main regulatory oversight body, so that if you were to pick multiple areas of law, then that advisory body could be populated with the necessary subject matter experts to evaluate the applications and the credentials and experience of those folks. So that's what I have for you in terms of the past consideration. These are the observations that I take away. It was very much conflated in the early years, but the focus is quite clear now. Looking at access and looking at partnering with regulatory stakeholders and other stakeholders, and also having this concept of oversight and starting modest and building from there.
Thanks, Randy. I think Leah has her hand up right now, so why don't we let her jump in?
Actually, that is from previously when I had my hand up, but I think it is a good time to see if anybody has questions or comments, because we're going to segue, I think, to looking at other state models right now.
This is Steve Fleischman. I had a question about the so-called treaties. You gave the example of military attorneys and title insurance. As I understand it, those professions are separately regulated, and the treaty simply allowed them to not violate the UPL prohibition. Do I understand that correct generally, that they have a separate body regulating them?
Well, let me just answer that by giving you the sort of the laundry list of the treaties that I'm aware of. Many of these were at the ABA level. They're beyond what was in the list from California, but starting in the mid-1930s, the ABA negotiated treaties with accountants, 1951, they're regulated. Architects, 1968, I think they're regulated too. Banks with trust functions in 1941, claims adjusters, 1939, collection agencies, 1937, liability insurance companies in 1969, life insurance companies in 1946, professional engineers, 1969, law book publishers. Now, I don't think you could put them in the category of, in terms of a regulated professional, but they were the subject of an interprofessional agreement. That was 1941. Real estate title companies, 1969, realtors, 1942, and social workers in 1964. So I think by and large, you're talking about other professionals, but I don't think it was exclusive, at least if you're talking about law publishers at that point.
Thank you.
Sure.
Any other questions before we move on to the next one? Oh, I think Angela, do you have a question?
Yes, well, more of a comment in terms of considering the history and talking about historical considerations. If we look at those, where we were as a society in 1990s, in the early 2000s, I think in terms of the legal professional community, what you'll find more is now another consideration taken into into consideration is that now there's been a shift and there's more diverse perspective, if you will. The voices that were speaking at that time and contributing to that regulatory, those regulatory bodies and that produce that regulation and those recommendations is very different. So now I think communities of color are now contributing to the overall narrative of what a limited access to justice looks like to us, and what our needs are in terms of being represented in this society, and making sure our needs are addressed. So I think that's another aspect of maybe if we were to have those discussions today, the narrative might be different, because then we can voice and contribute our needs.
Great, thank you, Angela. Any other comments or questions right now before we move on? Okay, Randy, back to your team.
And I think we're going to Russia transfer control of the PowerPoint to Mimi Lee.
I've already got it. So what I'm going to talk about is how other jurisdictions are interpreting what a limited license paraprofessional is. I'm going to focus on Washington's limited license legal technician program, known as LLT, and Utah's licensed paralegal practitioner program, which we'll call LPPs. I'll briefly cover the history of the programs and what areas of substantive law they allow paraprofessionals to practice. I'm also, towards the end of my presentation, going to cover the different types of limited licensing that is being considered in other jurisdictions. So let's start with Washington, since they were the first to implement this type of program. So why was the LLT license created? A civil legal needs study was commissioned by the Washington Supreme Court in 2003, and it found that the legal needs of the public were going unmet. As a result, in June of 2012, the Supreme Court issued an order adopting the LLT license to help address the justice gap. Washington became the first state to offer an affordable legal services option, which could be provided by a non-lawyer for those unable to afford services of a lawyer. So what is a LLT? A LLT is defined as a person qualified by education, training, and work experience who is authorized to engage in the limited practice of law in approved practice areas of law. So as we heard from the public commenter earlier, the analogy would be LLTs are to lawyers as nurse practitioners are to doctors. For example, a nurse practitioner can only perform some of the tasks a doctor can do, such as treat, prescribe medications, and order tests for a patient independently of a doctor, but they're prohibited from doing things like performing surgery. Similarly, triple LTs can do some of the tasks that a lawyer can do, as providing legal advice and completing court documents, but the scope of a triple LT's practice is also limited, even though they have a license to practice law from the Washington Supreme Court. As of today, triple LTs are only authorized to practice family law, which includes domestic violence actions, divorce, parentage, cohabitant abuse, civil stalking, and custody and support actions. But Washington is currently considering adding consumer, money, and debt law as an approved triple LT practice area because of the great unmet need among low and moderate income people. Triple LTs are prohibited from providing services outside the scope of the defined practice area, and they also have an affirmative duty to inform clients when issues arise that are beyond the scope of their practice. And although the amendments to the rules permit triple LTs to practice in family law matters, there are still limits to what they can do in some actions, such as de facto parentage actions, division of real property, bankruptcy, and disposition of debts and assets. So moving on to Utah. So Utah has a similar program, the Licensed Paralegal Practitioner Program. And in 2015, the Utah Supreme Court authorized the licensing of LPPs to assist clients in 3 areas of law based on a study that was done in 2014. The 3 areas of law that LPPs are authorized to practice in are family law, eviction, and consumer debt matters. The reason for selecting these approved practice areas for LPPs is that in 2014, cases involving family law, eviction, and debt collection had the highest concentration of self-represented litigants, and they relied heavily on self-help in these 3 areas. So now I'm going to briefly talk about a few states that have also began to study the addition of paraprofessional licensing in their states, and we'll start with Arizona. Arizona is considering authorizing a limited license legal practitioners program known as triple LPs, but not at the exclusion of other alternatives. In addition to the triple LP program, they're also exploring other types of programs, such as licensed legal advocate pilot program, which I'll talk about in a little bit. The task force is recommending a tiered approach for their triple LP program, which is something that was considered by ADLs. And what is meant by a tiered approach is that depending on a paraprofessional's education, training, and examination, some triple LPs may be able to perform a broader scope of legal type services, while those with less education, training, and examination would provide a more limited scope of legal type services. So like Washington, Arizona's task force is focusing on family law as an approved subject matter area, but they're also recommending limited jurisdiction civil practice matters, limited jurisdiction criminal matters that would not result in incarceration, and aspects of administrative law. So like I mentioned previously, a tiered approach would allow those with more education and training the ability to provide legal advice and make appearances in court. Currently, their task force's recommendation is circulating for public comment with a deadline of late May. So the licensed legal advocate pilot program I mentioned earlier is one type of an alternative to triple LPs. This is a program that was developed by the Innovation of Justice program at the Arizona School of Law in partnership with the Emerge Center Against Domestic Violence, which serves about 6,000 domestic abuse survivors each year. At this time, LLAs are only allowed to help survivors navigate the legal system, but they could be so much more effective if they were authorized to provide more legal assistance to these survivors. LLAs are authorized to identify legal needs and provide advice regarding the next steps of action, assist self-represented domestic violence survivors with completing domestic violence and family law forms, provide advice regarding obtaining court evidence and preparing for hearing and mediations. And they can appear with survivors at hearings, not in a representative capacity, but more in an advisory capacity. Oregon has also been taking steps in this direction. In September of 2019, Oregon State Bar approved a program for the licensure of paraprofessionals. And I would say Oregon has the most comprehensive set of recommendations, and it derived a lot of its recommendations from Utah and Washington's experience. In Oregon, licensed paraprofessionals are authorized to provide limited legal services to self-represented litigants in family law and landlord-tenant proceedings. Licensees are authorized to prepare, file, and serve forms and documents, provide information and advice relating to the proceeding, and communicate and negotiate on behalf of the client with another party. Both Oregon and Arizona are going one step further by recommending that licensees can accompany clients into court, not in a representative capacity, but to provide emotional and administrative support. And finally, Colorado, Montana, and New Mexico are other states that have also been studying licensing of paraprofessionals. The last thing I want to say is that there is no perfect model, and that, as you've seen here, each state has different areas of law that they're allowing paraprofessionals to practice in, and have different like standards for what they can and cannot do. And I think we can, this group here can benefit from the work that other states have done and learn from their mistakes and adopt characteristics of their programs that have shown to have positive results. And I just want to point out one more thing, which is that it appears that the substantive area of law that each state has recommended for allowing these paraprofessionals to practice in are in response to studies that have been conducted in those states showing that there's a great unmet need for these types of matters. And I don't know, we could take questions or we can move on to Andrew.
Yeah, let's, before we take questions, we were wondering if everyone could rename yourself on your screen, since we're taking notes and it's just hard to tell who's speaking or who's who. So if you could do that on Zoom, or I think it might be helpful as we take notes for everybody. And then I think maybe now we could go to questions or comments before we move on.
Chris, I was going to say, Russia can change the ones that are phoning and they can't change their name, but she can change it if she knows who the caller is.
All right, thanks, Ian.
Yeah, Chris, my question for Mimi, this is Steve Fleischman, is I'm wondering if she's read the Law Review article about the Washington LLLT program and whether she has thoughts on that article, because I read it and it didn't leave me with the feeling that the program is working particularly well up there.
I have not read that article. However, I know there were some concerns. I'm not sure if this article references this, but I guess the problem with Washington's program was that the types of requirements, the education requirements, the experience requirements, and the examination requirements were quite burdensome. They're, compared to other states that are considering programs or currently have a program, like, for example, like Utah, you were only required to have 1,500 hours of experience, whereas Washington's, it was 3,000 hours. For Utah, they had, you know, there was only, I think there was only 2 exams that you needed to take and have a certificate in another program. And in Washington, there were 3 exams you had to take. So I think some of the programs was entry into the licensing was a little bit more challenging for people than other states have created.
Yeah, those issues are discussed in the article, although I don't think they're a major focus of it. What I came away with from the article is just the economics are such that these programs, however well intended, don't really serve the low income market, because those people who may have a great need for legal services really just can't afford the services under the LLLT program just because of economics. And that in reality, the LLLTs in Washington are simply competing with lawyers for what I'd call sort of the middle income group, like family law, say a family of four with $100,000 that needs a will. And so it really isn't doing anything to address access to justice among lower income people.
Okay, thanks, Steve. I think we have a few more hands up. Leah, Stephen Hamilton, Sharon, Bashan, and Carolyn. So Leah, you want to go first?
Yeah, first I wanted to say thank you, Mimi, and I wanted to make sure the working group knows that we sort of intentionally focused the overview of other states' programs this time around on practice areas covered as opposed to tasks that are authorized within those practice areas or the licensing and regulatory structure, because as you saw from the roadmap, we're going to tackle those particular issues in subsequent meetings. And so when we come back to licensing and regulation, for example, you will hear more about how other states handle those issues. But I did want to go to Stephen's comments about Washington. I think this is going to be really critical in terms of the working group's development of the final recommendations for the California program. We are going to segue next into taking a look at the California Justice Gap study that we did complete last year. And you will see that the justice gap goes very high up the income ladder here in California. So there is an untapped market for legal services, even among those who can afford to pay something for the service. And that's a question of why the current market, the legal market, is not meeting that demand that is out there. So you do have the issue of a development of a program that will address needs that folks have quite high up the income ladder that are not currently being met. But the very specific issue of trying to develop a program that will address those at the lower income levels. Now, so we're talking about folks above the threshold for being eligible for free legal aid services, but yet still that we would consider low income. I think you raised an excellent point. Part of the economics in Washington, though, that is tied to the licensing requirements that Mimi referenced, because the cost of being licensed in Washington just to get your initial license is so high that that's part of what makes the sort of economies not work there. So I did want to say there is some connection between how rigorous the licensing requirements are and the cost basis that the triple LTs work from. So just wanted to make those comments.
Thanks, Leah. Stephen Hamilton? I think you're muted.
Yeah, I got it. Okay. Mimi, I love that chart that you did that was side by side comparing the jurisdictions. That was extremely helpful. My question is, based on your survey of the states where they already have the programs or they're in pilot programs, is it clear that family law is the subject matter area where the programs are both most needed and the most utilized?
I wouldn't say it's clear. I think it's the reason why they chose family law, at least my understanding, is that there was less risk involvement when it, as opposed to, selecting, the debt or consumer law or landlord tenant. I think generally a lot of the, for them, they picked family law because there was the greatest need in those areas. And there was, as far as I know, they were considered a little bit less, they're not risky types of substantive law areas. However, it was, I guess, less I don't know. Randy, could you jump in here?
Hi, this is Randy. So the family law area is one that is routinely mentioned in this context because it is an area where you have the statistics on the pro se litigants. And so I think that was oftentimes the driver going all the way back to the Public Protection Committee in 1989. They were looking at pro se litigant filings and finding that in family law, it was high even back then, and using that as an indicator of need for these other paraprofessionals to step in. But I think I agree with Mimi that you couldn't necessarily say that that was absolutely the clear-cut area of law that should be addressed first. If you go to the board resolution, the most recent version of it, they were looking at one area of law, and they tagged landlord-tenant.
Thanks, Randy. I think Sharon, how about Sharon Bashan has her hand up? Sure. Okay. How about Carolyn? Carolyn Shining, I believe.
Yeah, hi everybody. And I have two questions, probably for Mimi, but maybe for Randy. And thank you so much for all this research. One was real simple. I know New York has something called a navigator, and I wonder if anybody looked into what those do and what they don't. I've kind of got a little bit of understanding of that, but wondered if you guys had dove into kind of where that came from. And the other is I've done some pro bono and low bono conservatorships for elderly people. And I don't see that as a practice area in these other states. And, you know, I know the law libraries do, I think that does some self-help seminars and that kind of thing once a month down at Mosque. So I'm just wondering, has that ever come up anywhere else?
This is Randy. So the court navigator issue is one that overlaps with the paraprofessional proposals, but has been looked at separately, I believe, and actually implemented separately. And so even here in California, you might have a program where non-lawyers are allowed to assist litigants in navigating the court, to accompany parties to court, to not advocate, but to assist the parties to understand things that are being asked of them. But they haven't been, in terms of what we found, built into, so to speak, a paraprofessional regulatory scheme that is aimed at delivering legal services to the consumer so that they can actually handle their legal matter. And so in my mind, the traditional, if you will, exploration of a paraprofessional regulatory program is akin to the limited scope representation or the unbundling concept, where previously a lawyer would have to provide the entirety of all of the services for a specific case or matter. This concept of bundling and unbundling was really not a recognized way of delivering legal services, 20 plus years ago. But it began in the area of family law, and then it became general civil in terms of what the rules of court in California allowed. And so the idea was that if the client can handle certain parts of the legal representation, some of the sticks in the bundle themselves, and a lawyer can handle other parts of it, the necessary part of going into court, for example, but the client could handle certain interfaces with the opposing parties, certain drafting and other types of activities in their case or matter, that would be an acceptable way. And with the rules of professional conduct that became operative November of last year, you actually have recognition of that. And so what I see as the, again, traditional paraprofessional regulatory scheme, excuse me, is allowing the non-lawyer, like the person who's representing themselves with the help of a lawyer, to do some legal services themselves. And so a navigator starts to look a lot like an advocate. And so that's why I think there is this concept that they might be something to be kept separate. I don't see the actual, I want to call it, comboing of authorization for what would otherwise be an authorized practice of law to include advocacy or court participation together with the delivery of certain limited types of legal services, limited advice, limited drafting, but it doesn't mean that it can't be considered. In fact, at one of the ADL's meetings, it was reported by our court liaison that funding had been allocated for court navigator exploration. And so it is something that is going to happen. Again, I don't know if you want to necessarily intertwine it with the traditional paraprofessional licensing or regulatory scheme.
This is Sharon Bashan. Can I ask a
Oh, yeah.
question?
I'm sorry, Sharon. I was just going to call on you. Sorry about that.
Oh,
Yeah,
and I'm
go ahead.
sorry. I was speaking before, but I realized I was muted.
Yeah, me too. Okay. Go ahead.
So I'm wondering if any of these states have collected measurable outcomes or rates of malpractice, at least what's been reported. And I guess my second question is, are there any states where the paraprofessionals have been strategically utilized by legal aid organizations, either as staff or as pro bono volunteers?
Good question. Randy?
Yeah. So on the latter question, it came up, I think, once at one of the ADL's meetings. One of the co-vice chairs is Toby Rothschild. And I think we can sort of track back to that discussion and see what, if anything, there might be information. I don't know if anyone from Helen's group might be able to give us some insight, but I do believe it came up. I'm not exactly sure what the answer is, but we can look into that. Regarding the malpractice side of it, there was the report reviewing the Washington program, and that is something that we can make sure this group has. I'd have to go back to it myself to see if there was actually malpractice type records of proceedings where the non-lawyer paraprofessional has actually found to be liable. The ADL's task force, during one of its public comment sessions, did have a representative of the legal document assistance group appear, and we did ask about claims of misconduct or malfeasance or nonfeasance, and they were not able to report any instances of that to their knowledge. Although in that same discussion with those representatives, it was explained that there was actual limited regulatory oversight, that the posting of a bond with the Secretary of State was about it. The registration with the county was about it. And as a group, they weren't aware of enforcement, if you will, actions by either the Secretary of State or by any county. But that's anecdotal.
Okay, thanks, Randy. So we have a couple more questions from Ira and then Bonnie. So Ira, you're up. Okay, how about Bonnie?
Hi, I'm Bonnie Huff with the Judicial
Huff.
Council. And I guess I just wanted to clarify the point that Randy just made about the court navigators. That is a proposal that is in the governor's budget. However, I think given that, but there is not funding yet. And I think that there are many concerns given the status of the budget. I think we are pretty clear that new programs are unlikely to be moving forward at this time. So just to clarify that. And the proposal for court navigators was very much a non-legal assistance. It was really working in the courthouse and getting assistance with translation services, moving from one place to another, providing all the kind of non-legal support that is sometimes self-help centers are providing, but trying to do it at a lower cost, and then also identifying in order to provide expanded services, but also identifying problems that self-represented litigants have with the court process so that more systemic changes could be made. So it's a slightly different vision, but I just want to let you know that. And Sharon, there has been some research on the Washington, most of these programs actually haven't really started yet. The Washington program, there was some research done, but there were only 6 people who had gone through the program, and I think only one of them who was providing services independently. So there's, last time I saw there was not a lot of data yet, but Mimi may have more information than I do. Probably does.
Okay, thanks, Bonnie. Ira, are you back or shall we move on? Okay, Randy, do you want to introduce the next item?
Sure.
Can you hear me now?
Thank you, Bon.
Oh,
Thank
sorry.
you. Oh, is that Ira?
Is that Ira?
Yeah.
Okay.
Yeah, I'm
Ira.
just getting used to this. Anyway, the landlord-tenant as a subject of, Randy mentioned it, so I wasn't going to say anything, but I do want to emphasize it. Maybe I don't need to emphasize it. Maybe everybody already knows, but there's a tremendous need for legal help in land for tenants, frankly. And I'm working on this with a whole lot of lawyers but with a couple nonprofits here in Los Angeles. And one of them has a lot of data on the very low percentage of representation of tenants in eviction cases, and on the greatly increased success of tenants in eviction cases when they're represented by, well, now it has to be lawyers, but maybe it doesn't have to be through our program.
Thanks, Ira. Appreciate that. I think Angela has a question now.
Well, not so much a question. I apologize. My iPad decided to do an update, and I just got the tail of the last one of the questions about whether there's any whether the paraprofessionals volunteer at any local organizations. So here in Sacramento, the majority of our members got their start working in many of the local clinics, volunteering with WEAVE, which is a domestic violence organization, or My Sister's House. And that's how a lot of us get started. Many of us were either worked for an attorney or some of us, one of our members here on the channel actually taught at the local law school. And so, or in some other paralegal program. So, and I apologize if, but that's what I thought I understood the question was toward the latter part.
Okay, thank you. Good point. It's almost kind of like a pre-apprenticeship program or something like that. It sounds like, but okay. Any more questions right now? Otherwise, I'll turn it back over to Randy, and I think he'll be able to introduce Andrew. If that's right.
Thank you. So the next section is going to be covering the existing landscape of law-related services providers that we have in California, and we have Andrew Tuft, who is the supervising attorney in the Office of Professional Competence. Andrew, do you have control of the PowerPoint?
I do. Can you hear me okay?
Yep.
Yes.
Yes.
Okay,
Thanks, Andrew.
great. Good morning, everybody. As Randy said, yes, my name's Andrew Tuft. I'm the supervising attorney in the State Bar's Office of Professional Competence. It's a pleasure to be with you all this morning. I'm going to provide you, my portion of the presentation is going to involve providing you with a brief overview of the regulatory scheme for law-related service providers in California. This overview includes describing who they are, what they can do, and I'll briefly touch upon how they're regulated. I do want to acknowledge, although I'm focusing on 4 categories, that there are additional sources for assistance in California. For example, the Code of Civil Procedure provides for personal advisory services with regard to small claims court actions, and the Family Code provides for a support person to assist a person who alleges to be a victim of domestic violence. Those are just 2 examples that are outside the 4 I'm going to be focusing on. However, the 4 that I'm focusing on are regulated under the Business and Professions Code. They're regulated under what appears to be a common scheme, and they're more in line with each other. And so as a result, my presentation focuses just on these 4 individuals. And as you see on this first slide, the 4 categories we'll be discussing are legal document assistance, which are oftentimes referred to as LDAs, unlawful detainer assistance, which are often referred to as UDAs, immigration consultants, and paralegals. Okay, so the legal document assistant is defined in Business and Professions Code at section 6400C, and is defined there as any person who provides or offers to provide self-help services to a member of the public who is representing himself or herself in a legal matter. Self-help services are actually defined in the statute as well, and they are described there as a handful of things, including providing general published factual information, which is had been written or approved by an attorney, regarding legal procedures, rights, or obligations to self-represented individuals, and making published legal documents available to a self-represented individual. With respect to those 2, I should note that no one has to be registered as an LDA or registered as anything to provide that type of information. You know, there are many ethicists and other practitioners who have acknowledged for hundreds of years this concept that the law belongs to nobody. And so, you know, providing information about the law, where to find information about the law is not prohibited or regulated. Turning back to the statute of, you know what? I realize I'm a slide ahead. I apologize. Let me get back here. Okay, here's where I meant to be. Turning back to the statute, which describes what self-help service an LDA can do. They can also help complete legal documents in a ministerial manner by typing or completing the documents selected by and at the specific direction of the self-represented individual. And they can also assist by filing and serving legal forms and documents at the specific direction of a self-represented individual. Unlawful detainer assistant is defined under Business and Professions Code at section 6400A, and an unlawful detainer assistant is defined as a person who for compensation renders assistance or advice in the prosecution or defense of an unlawful detainer claim or action. The statute also provides that this includes any bankruptcy petition that may affect the unlawful detainer claim or action. And I know this working group is comprised of several practicing attorneys as well as a few judges. And so many of you may be familiar with what an unlawful detainer action is. But for anyone who's not, I'll just briefly describe an unlawful detainer action is a special court proceeding It's a way to evict someone from the place where they live or work. This usually, the need for one usually occurs when the tenant has stayed after the lease is up, the lease is canceled, or the landlord thinks the tenant hasn't paid their rent. Of course, there's a wide variety of ways in which such a dispute can arise, but those are typically the most common ones. And the reason why an unlawful detainer proceeding is necessary is because it's against the law to personally evict someone yourself. Only a sheriff can evict someone. And that's why you need an unlawful detainer proceeding in order for the landlord to obtain what's known as a judgment for possession. And once the judgment for possession has been obtained, that can be provided to a sheriff, and the sheriff can enforce the judgment. Turning now to immigration consultants, they are defined under the Business and Professions Code at section 22441A, and they're defined there as a person who gives non-legal assistance or advice on an immigration matter. The statute describes what the non-legal assistance or advice may include, but the statute is clear. It's not limited to these things. And it says the statute provides that they can help complete forms provided by a federal or state agency, but they can't advise the person as to their answers on those forms. They can help translate a person's answers to questions posed in these forms. They can help by securing supporting documentation such as a birth certificate or perhaps an existing visa that may be necessary to help complete the forms. They can help by submitting completed forms to the applicable agency on a person's behalf and at the person's request. And they can assist by making referrals to persons who could undertake legal representation activities in an immigration matter. Paralegals are defined under the Business and Professions Code at section 6450A. And a paralegal is a person who holds himself or herself out to be a paralegal, who is qualified by education, training, or work experience, and who either contracts with or is employed by an attorney, law firm, corporation, governmental agency, or other entity, and who performs substantial legal work under the direction and supervision of an attorney. And that work has to have been specifically delegated by the attorney to the paralegal. The statute 6450A also describes what the permitted activities for a paralegal to perform include. And I just want to pause to note, compared to the other three authorized law-related service providers, it's clear, at least to me, and as I was reviewing these materials and preparing for the presentation, what a paralegal can do is by far the most broad of the three. The caveat being they are supervised directly by an attorney, but nonetheless, as I read this list to you, hopefully it'll show clearly how broad the activities a paralegal can do compared to the other three. And the statute permits a paralegal to engage in the following: case planning, development, and management, legal research, interviewing clients, fact gathering and retrieving information, drafting and analyzing legal documents, collecting, compiling, and utilizing technical information to make an independent decision and recommendation to the supervising attorney, as well as representing clients before a state or federal administrative agency if that were to be permitted by statute, court rule, or administrative rule or regulation. So in your materials, there's a 3-page table which describes these four categories of folks. And in that table, the enforcement scheme is referenced. I know it's not a focus for today, but the tail end of my presentation here is going to touch upon this. And as you'll see, other than paralegals, all the paraprofessionals are registered. Legal document assistants, as well as unlawful detainer assistants, must be registered by the county clerk of the county in which their principal place of business is located and in which the registrant maintains a branch office. They also must provide proof of satisfying the bond requirement prior to registration. Immigration consultants are registered with the Secretary of State. The registration includes the posting of a bond and disclosing whether the applicant has been convicted of certain crimes or has been held liable in certain civil matters. And immigration consultants must also submit fingerprints and are subject to a background check. In terms of any continuing legal education requirement for these paraprofessionals, there is no continuing legal education requirement for immigration consultant. The LDAs and UDAs must complete 15 hours every 2 years. However, they aren't required to conduct any specific area of law, including legal ethics. It can be any 15 hours. There's no minimum requirement of an ethical education requirement amongst those 15 hours. And the completion of the 15 hours is attested to at the time of registration renewal. So every 2 years, they must renew their registration with the county clerk. And I believe they just simply check a box and say, yes, I've completed the 15 hours in these last 2 years. A paralegal is required to complete 8 hours of CLE every 2 years, 4 of which must focus on legal ethics. The other 4 can be in a general area or an area of specialized law, and that's confirmed by the paralegal's supervising attorney. Several of the paraprofessionals have specified prohibited activities, some of which that's common amongst all of them include, at least with respect to LDAs, UDAs, and immigration consultants, they're prohibited from making a false or misleading statement while providing services to the client. They can't make any guarantee or promise unless stated in writing and supported by some factual basis. And they can't state that they can or will obtain special favors or have special influence with the applicable agency before which the self-represented person may be appearing. I can see personally why that would be so important in the immigration context. And lastly, none of the 4 can engage in the unauthorized practice of law that's specifically and expressly prohibited under the statutory scheme. In terms of how enforcement occurs for misconduct under the statutory scheme, violations of the statute governing each law-related service provider is a crime punishable by either a fine and/or imprisonment. For paralegals, it requires a second violation to rise to the level of a misdemeanor. Some second and subsequent violations for these paraprofessionals are felonies. The violators are subject to civil liability for an injured person's individual suit for injunctive relief, restitution, and damages. For LDAs and UDAs, the county clerk must revoke the registration for those individuals when required by the statute. For example, if the registrant engaged in the unauthorized practice of law, or if the registrant committed a misdemeanor violation under the statutory chapter that would require revocation by the county clerk. For immigration consultants, the attorney general, district attorney, or a city attorney may bring a claim for injunctive relief, restitution, or other equitable relief. And finally, the Secretary of State can issue a cease and desist order against an immigration consultant when that person has failed to comply with the bond requirements or does not pass the background check. And so just in conclusion, some takeaways that come to my mind as I look at these paraprofessionals is the scope of services that these individuals are permitted to provide is limited, as I think you can all see. Generally, they can only act at the direction of the self-represented person. And as a result, these individuals aren't able to demonstrably reduce the justice gap as they're currently constituted. The individuals are all precluded from giving legal advice or engaging in the practice of law as part of the services that they are specifically able to provide to consumers under the statutory scheme. And several of the studies that address the justice gap, whether it's the study undertaken by Professor Rebecca Sandifer or the study conducted by the State Bar of California, which you'll hear about a little bit later. Both those studies note that a common problem for consumers is the inability to identify their problem as being legal in nature. And if a paraprofessional were perhaps able to identify certain issues as being a legal problem and could maybe help the consumer navigate their way towards a legal solution, such a change could perhaps more directly help reduce the justice gap. The elephant in the room obviously is the nebulous definition of what constitutes the practice of law. But you know, the middle ground there of authorizing individuals to provide more services with respect to identifying problems as being legal and available legal solutions, I think could go a long way to addressing the need we all recognize as being needed to address here. And finally, you know, the regulatory framework doesn't appear to be centralized or consistently applied. The regulatory scheme relies largely on voluntary compliance by the paraprofessional in terms of their reporting obligations. The immigration consultants do submit fingerprints and are subject to a background check. But other than that, you know, unless a victim seeks a private right of action or seeks redress with the help of a government attorney, you know, it doesn't appear that enforcement occurs regularly. And lastly, you know, paralegals are a little bit of a different animal. They're regulated, they're supervised by an attorney. An attorney has an obligation to supervise their non-legal assistants under Rule of Professional Conduct 5.3. And so, you know, when a paralegal engages in misconduct, the supervising attorney is liable for that misconduct. And, you know, any form of malpractice that might occur as a result of the paralegal's work or assistance could, you know, relay to the attorney with respect to malpractice or other civil exposure. And with that, my presentation is concluded.
All right, thanks, Andrew. I don't see any questions right now. So we're pretty much well ahead of.
I have a question. This is Elizabeth Olvera. Sorry to interrupt.
Oh, okay.
Hi. So I am representing CALDA, the California Association of Legal Document Assistants. And I just want to say this is a great chart. The only thing I would just make reference to would be for legal document assistance under authority. I do see Business and Professions Code section 6400 quoted. The only thing I would add to that is the legal document assistants do work under a contract that they have to show every consumer, and that contract is set out in the California Code of Regulations through the Department of Consumer Affairs. They have set out the contract that we have to show every client, and that's section 3900 and sequence. But the contract itself is at 3950. That's the only thing I would add under authority, that we work with them kind of. Yeah.
Thank you, Elizabeth.
Okay. Thanks, Elizabeth.
Update this chart. And I might email you for that citation. Thank you, though.
Thanks, Elizabeth. I think Ira has a question.
Yeah, I have a question. As far as I can tell from researching this, in order to do the things that a paralegal can do under the statute governing paralegals, you don't have to be licensed as a paralegal. You do have to work under an attorney. But so my question is that correct? I couldn't tell for sure.
Hi, Ira. Yeah, this is Andrew. So the statute at 6450, and forgive me, I don't have the precise subsection, but there is an eligibility requirement for a paralegal. In order to obtain paralegal status or hold yourself out as a paralegal, there are 4 ways to do that. You either have to have an ABA approved paralegal certificate, or you have to obtain a paralegal certificate from a qualified institution that requires 24 semester units in law-related courses, or you must have a bachelor's degree and 1 year of law-related experience under the supervision of an attorney, or you have to have an high school diploma or general equivalency diploma and 3 years of law-related experience under the supervision of an attorney. So if you check off one of those 4 options, Ira, and you are employed directly by an attorney, governmental agency, corporation, the list of folks under 6450A, then you would qualify to perform the services permitted under the statute. Paralegal.
Well, Andrew, I guess I didn't make my question clear enough. I really didn't. My question is this: as far as I can tell from case law, somebody can lawfully perform any of the services that a paralegal can perform under these statutes, the paralegal statutes, and if they do them, the services supervised by an attorney, and that is proper and can even be paid for by an attorney's fees award, in an attorney's fees award, even if the person doesn't have the paralegal license and doesn't meet any of the 4 criteria that you just recited from the statute. That's my understanding from looking at some cases just this morning, actually.
Can I speak to that? This is Julia Brynelson. May I speak to that?
Please. Oh,
sure.
As far as I'm concerned,
yeah. I teach at American River College in our legal studies department. We're an ABA approved program. We, as far as I know, are the only ABA approved program at a community college in Northern California outside of the Bay Area. And I've been teaching since we got ABA approval and throughout. So I have over 14 years of experience, and I also teach ethics in this area. And what I can say is this: you are supposed to be able to perform these duties as a paralegal. You must qualify with 6450 at SEC. Furthermore, it is a valid objection that if you in fact try and charge fees for paralegal services and you don't have a person who is a paralegal under 6450 subdivision C, that is a valid objection to having to pay them.
Well, apparently it is. There's. I appreciate that, but apparently there's some uncertainty in the law here. I just read cases this morning that there were applications for attorney's fees, and in that, not everybody might not know this, but when you apply for attorney's fees in a lawsuit, you can include the charges for people other than attorneys. So in these cases, people who were not paralegals, there was an application for an award of fees for them. They were not certified paralegals, but they were allowed fees. They were awarded fees, just not at the paralegal rate, at a lower rate. Maybe I should send some of these cases to everybody.
Well, then I guess I would just say then they are not paying paralegal fees. If they somehow were able to put them in a category of fees that are non-paralegal, non-attorney, then that's a whole different situation. But I teach and counsel the Sacramento community that if you are going to seek paralegal fees, the best thing that you can do is not only have a copy of your paralegal's transcript and or certificate, but that especially if you're the person signing off that they're completing their continuing legal education through you, that you keep all this documentation, because it is it can become quite substantial
in terms of billing them out at a fairly high level. And so I'm not surprised that somebody was able to get fees for someone who did similar type work. But in terms of the law, as I understand it and have been teaching it, you cannot count those as paralegal fees.
Yeah, that's what I read too. They called them legal assistant fees, and they gave them a lower rate.
Okay, so let me clarify that for the group just to make sure we're all speaking the same language. Although I'm an attorney, I know that most attorneys are unfamiliar with this, but in 6450, I think it's 6456, it will tell you that all of these words are synonymous outside of the state of California. So the term paralegal, legal assistant, all of those terms are synonymous and are codified in that statute. The only people who are legal assistants, in my understanding, that are not paralegals are the legal assistants in the state government or county government or federal government. They are governed by their own bargaining agreement into what they can promote through as titles. But in California, if you have a legal assistant, and I know that there's a lot of lawyers who like to call their legal secretaries legal assistants because it appears to be more professional. But that in fact is incorrect. A legal assistant in the state of California is a paralegal, and those terms are synonymous.
It sounds like these judges got it wrong. That wouldn't be surprising.
Well, I'm not sure that they got it wrong if they awarded attorney's fees, but they at least got it right in saying they're not paralegal fees.
Great. Thank you, Julia, and for that information. So we don't have any more questions right now, but we are definitely running ahead of schedule. So I just want to throw out a couple options. We could take a quick break and come back and do the justice gap study, or we could just break for lunch right now and take an early lunch. Maybe we could resume at 12:15 and start again. I'm open. I just want to kind of throw it out there to the group. I think also what we want to do, I know we did introductions earlier, but what we'd like to do, just because we're taking notes and everything, is to have the members of the working group introduce themselves, say their name, and tell us where they work and their subject matter expertise. I mean, we could even do that right now, and then we could take a break for lunch and then come back and start. Does that sound okay?
Yep.
Okay, so go ahead.
Oh, I'm sorry, this is Angela. So I did have a question about the current presentation, and also to supplement Professor Brynelson's comments. The one thing that came up was the certified paralegal. That's a completely different designation. There are supplement certifications that paralegals can obtain through local associations, and so, or statewide and national associations. So there's not a certification per se. The Business Professional Code 6450 qualifications is for a degree, but not quote unquote certification. A certified paralegal is something different through an actual association or other body, and every state has different testing and examination requisites for that certification title.
Okay, thank you. Thank you. Angela, I think you're a member of the public and not on the working group. I'd be I think we just can't have you just jump in. Sorry about that. Yeah, it's just this is right now for the working group members. So why don't okay, so do we want to take a break now for lunch, and then we'll come back and then we'll ask the members of the working group to just tell us where they work, name where they work, and their subject matter expertise. All right.
Sure.
Okay, so hearing anything,
Chris, this is
yes.
Erica. I had emailed the group yesterday. I have a bench meeting at 12:15 and I want to attend that because we're going to talk about our plan to sort of try to expand services at our court. So I won't be here from 12:15 to 1:15, just letting you know.
From 12:15.
If that's when you're going to have people introduce themselves, would you like me to do that now or?
Yeah, well, you
later?
know what? Why don't we just do the introductions now, if we can?
Sorry.
Yeah, no, that's fine, of the working group members, and then we'll take a lunch and then we'll come back, okay? So, Russia, can you go ahead and coordinate that, this next part?
Chris, I'm sorry to jump in, but
Sorry.
if you don't mind, just knowing, Judge, you won't be available starting at 12:15, I do think it would make sense to go through the justice gap.
Okay.
Just because I think that's a really important piece for her to see, if you don't mind.
No, perfect. Let's do that.
I'm sorry to hijack it.
No. Thank you, Jess. That's not a problem at all.
Okay.
Plus, you're the last person I want to make upset, since this is my first meeting chairing this. So
You're doing a wonderful job. It's hard to do it by Zoom too. You're doing a great job.
It's crazy. Okay, so I think I'm going to turn this over to the dream team here, right? Helen Hong and Lisa Chavez and Leah, right?
For the Justice Gap study, we'll start with Helen Hong and Lisa Chavez. Yes.
Okay. Let's do it.
And Andrew, I'll need you to release control of my screen so that Helen can request control.
Just did it. Sorry about that.
Good morning, everyone. This is Helen Hong. I'm the Director of the Office of Access and Inclusion, and Lisa Chavez and I will be going over the Justice Gap study. And so with this, I am going to be shifting. One second. And so first, we will be going over the history of the Justice Gap study. And so Russia, I can't actually advance. Oh, there it goes. I got it. Okay. So Lisa, are you on? Do you want to start? You know what? I think, is Lisa on?
Let me look for her. I don't see her name.
She might have been just waiting to join us at 1.
I believe so. Can you do?
Yeah, I can just do this. So, so historically, the Justice Gap was really focused on looking to see who was requesting legal assistance, who was going to legal aid, and who was going to the courts. And the unmet need of the clients was considered the Justice Gap. And then so that was considered the piece of the pie. The blue was considered the Justice Gap. Now, in 2007, the Legal Services Corporation, a large the federal organization that funds the largest legal aid programs throughout the 50 states and 2 territories, asked broader questions about what Americans felt and their behavior about civil legal problems as a whole. So not necessarily asking about, have you filed for bankruptcy? Have you been evicted? But asking broader questions about, have you been denied medical services although you have health insurance? Were you unable to get credit after you filed for bankruptcy? Were you unable to receive your veteran benefits after you were discharged? Or were you unable to get your job back after you returned from military service? And this survey revealed a different, much larger gap about the legal problems and the services available to meet them. So what California, what the bar did was we actually employed the same company that did the Legal Services Corporation study. That's the National Opinion Research Center at the University of Chicago, to survey nearly 4,000 adult Californians that mirrored the census of California to understand the civil legal problems that they faced and what they did to resolve them. Now, we slightly changed the national survey to reflect Californians' needs. We actually asked about questions about immigration. We focused on the rural areas of California by drilling down to actually the census tracts to understand what how geography impacts services and the availability of resources in those different areas. Like the national survey, we also oversampled seniors, people that have served in the military, survivors of domestic violence and sexual assault, as well as Spanish speakers and other subpopulations, like, people with disabilities. Along with that, we sent a survey to nearly 70 different direct legal services providers at the state bar funds. And so we distribute, this year we'll be distributing more than $80 million to 100 legal aid organizations. So the intake census actually asked these legal aid organizations for a 4-week period, who's coming to your doors? What kind of services are they asking for? Are you able to fully resolve their problems, partially resolve their problems? Are you unable to help them at all? Then we looked at what was the state of the recruitment and retention of legal aid lawyers and executives at these legal aid organizations through a partnership with the Legal Aid Association of California, which conducted surveys and follow-up interviews. And lastly, we conducted a larger survey of ABA and California accredited law students to understand how the cost of legal education impacts their career choices and access to justice, understanding that the vast majority of the services that legal aid programs provide are based on the attorneys that they employ. So what are the key justice gap findings? To no one's surprise in this group, we found that more than 55% of all Californians experienced at least one civil legal issue in their households. And that we see that more than 13% of Californians experience more than 6 or more problems. And this was true if you were lower income, as well as if you were a person that was a survivor of domestic violence or sexual assault, you were 8 times as likely to have legal problems. What we found was, because we also asked, what kind of problems are you experiencing? And then secondly, which of these problems would you consider severe or substantially impacting your life? So health, finance, and employment were the highest prevalent legal problems faced by Californians, regardless of income. So we actually surveyed 2 populations, unlike the national survey, which only focused on low-income Californians. We asked what the behavior and experiences was for Californians who are living at 125% of poverty or below, which for California is what makes these families eligible for free legal services, which I want to note is a family of 4 living on an income of $32,000 a year. So if you're making $35,000 a year, you would not qualify for legal aid unless you were another special category like a senior or a person with a disability. What we also found is that fewer than 1 in 3 Californians actually even sought legal help, which, as Randy and Andrew has mentioned, it highlights the knowledge gap about legal issues. And that when we compare that to the intake survey, that even with the resources that are that legal aid funding, that legal aid organizations have, they can only fully resolve 1/3 of the problems that are coming to their door. And again, that's only the 1/3 that's actually seeking legal services. So that is a minority of a minority. We also see that 1/3 of legal aid attorneys are planning to leave within 2 years. And we'll talk about the reasons for that. And that the median, so half of all of the law students that are graduating from ABA law, of the students that are graduating from an ABA school, that the median debt is $147,000. So we're going to be digging into, oh crap, sorry. Let me just go back. So as we discussed, what we see is that the justice gap exists at all incomes. The first bar is the families that would qualify for free legal services from a legal aid organization supported by the state bar. And we see that the justice gap in terms of the percentage of problems which help was inadequate or no help was received was 86%. What you see is that even if you are making $32,000 to $51,000 for a family of 4, the justice gap is actually even higher at 89%. And even if you're making at $154,000 for a family of 4, the justice gap is 78%. And so I know that there's been conversations early on this call about, what market is some of these categories taking, but you can see that there is a huge gap regardless of income. And we'll talk about where these individuals go for legal help and what are some of the barriers they face when they're seeking services in terms of where the needs are and where Californian state they need the most, where the problems are the most severe. So again, only 30% of low-income Californians sought legal assistance, and that's for low income. And that was only marginally higher for Californians above the 125% federal poverty level. When we asked these survey participants, what were your top reasons not seeking for legal help? The vast majority, between 31%, would say that they weren't even sure it was a legal issue, especially when you're thinking about some of the top problems of finance, employment, or health. And then they decided to deal with the problem on their own, but that is also impacted if they knew it was a legal problem that might have changed the behavior. Then worried about cost, didn't know where to look, and fear to pursue legal action. Now, where are people going to receive help? So when we're saying offline, that's either on the phone or in person. They're looking for legal advice, helping filling out documents, either negotiation, referrals, or representation. Online, they are looking about basically what are the procedures, what is the rights that people have, how to get information, or what is the problem, and looking for a lawyer. Now, when we talk about what are the types of legal problems reported, as I mentioned, the most common problem, so the prevalency within the households that rank the highest is consistent regardless of being low income or above the federal poverty level. It's health, finance, and employment. But where we see the difference is when people actually then say which problems actually have a substantial or severe impact on my life. That actually changes, and you'll see that it actually changes their behavior and how they seek and receive legal services. So not surprisingly, especially as you've gone through the data between Utah and Arizona, children and custody are within the top 3 regardless of income. Then it becomes veterans issues and then income maintenance for low incomes. For those above 125, which I think this group is also really digging some, asking questions about, our veterans issue. And I want to say the veterans issue kind of cross over all types of issues. It's about VA benefits, it's employment, about getting your job back. It's about some of the government benefits as well. Then it's children in custody and then family law. So then if we look at, what are the types of problems Californians actually sought and received legal help? So again, this goes back to the 30 or the 32% of Californians that said, okay, I'm going to actually look for services. You see, for all Californians, it's wills and estates, custody, and then family law. For Californians at below the poverty level, it's custody, home ownership, and immigration. And then for Californians above 125%, it's wills and estates, family law, and custody. And I want to just pose this question. Now, these are areas in which, one, when we talk about the knowledge gap, Californians may say, oh yes, for wills and estate, I need a lawyer. For custody and family, it's what they perceive a lawyer is required, or I will spend resources in order to fight for my kids or to deal with this divorce or those other issues. At the same time, for low-income Californians, this also could deal with what is actually available for services for this population. What is actually being outreach to? What are the resources available? We know in the last several years, there was an influx of money for immigration services, not only throughout the state, but through county efforts, as well as community redevelopment and home ownership issues after the foreclosure crisis. So that is the portion on the justice gap. I'm happy to ask questions. It is a robust data set, which is on the State Bar website. We really wanted to focus this on the high-level findings that I think will be informative to this group as they talk about how limited license technicians or other limited license professionals may be able to reach these populations that clearly not only need services, but that are affordable as opposed to an average attorney that is charging $373 per hour.
Helen, I think Leah has a quick question.
Sure.
Yeah, I just wanted to ask Helen if you could clarify the difference between family and children in custody.
Sure. So for family law, that was related to divorce. Hold on, let me just make sure that I have that. The children in custody is related to custody orders. Hold on. So family is related to adoption, custody, visitation, separation, annulment, parental rights termination, paternity support, and other family law matters. And for, oh, hold on, excuse me. I'm in the wrong section. Hold on one second. This is what happens when you guys are ahead of schedule.
Yeah. I think Carolyn has a question afterwards, after this question, after Leah's.
Oh, I can ask it later.
Oh, maybe we can go ahead and have you ask it while Helen.
Oh.
Yeah.
I was just wondering, when she mentioned the data set, where is that on the State Bar website?
So if you go to if you just Google access to California Justice Gap, State Bar, it'll take you to that webpage, and it actually has the full report by the NORC, and then it has our executive report, and you can actually download the data sets in Excel or CSV through our website as well.
I'll let you know if I can't find it.
Let me just clarify, Chris, if I may. If you're on the State Bar's website, if you click on Access to Justice, on the right-hand side, there are several tabs. You click on Access to Justice, and then across the top, oddly enough, you click on Access to Justice again. You'll see on the left the link to the California Justice Gap Study.
Okay.
So Leah, thank you for asking that. I'm sorry, I was on the wrong page. So family has to deal with issues of adopting a child, difficulties being appointed as the guardian of a child, filing for divorce or separation, difficulty collecting alimony payments, experience domestic violence or sexual assault, and problems involving the vulnerable adult being taken advantage of. For children in custody, it was about agreements about custody or visitation agreements, a custody or visitation agreement not being followed, problems collecting or paying child support, paternity problems, also related, this was related to issues with aging eligibility for foster care. And so some of these were related to parents or guardians in their household.
Helen, can you tell us what page that is?
So this is in the NORC report from November 2019 on page 57.
Thank you.
Thanks, Helen. I wanted the group to hear, I remembered that the family law category was quite broad. And I think, Carolyn, you had mentioned earlier, someone asked about conservatorships. And so both guardianship and some types of conservatorship matters are kind of lumped in there. So.
Other questions for me?
Hi, this is Sharon Bashad. I'm wondering what the finance category encompasses.
So the finance categories, well, and what was really interesting is that when Californians, regardless of income, are not seeking legal services, number one resources are family and friends. So the finances are actually questions about getting credit because of identity theft, being a target of unfair lending practices or internet scams, problems with debt reduction or credit repair services, problems with terms for repayment of payday lenders, problems related to legal financial obligations, harassments by creditors, problems for pay for or the repossession of a car, filing for bankruptcy, garnished wages, disconnection of utilities due to non-payment or billing dispute, as some examples.
Thank you.
Thanks. Okay. I don't see any more questions. Helen, are you finished? Or you?
Yep, that's it for me.
Oh, you are. Okay. All right. Thank you very much. So it's 12:02. So do we want to take a break now for lunch, and then we'll come back and then we'll do the introductions and everything and area specialty for the working group members? Okay, so 12:03, why don't we reconvene at 12:35? Does that work for everybody? Okay, let's do it. Thanks, everybody. Thanks.
Bye.
Having the members introduce themselves and
Yeah, I guess
provide their.
great place to start. I'll go in alphabetical order of the members group. Does the chair want to start, or do you want to go last?
I'll go last.
Okay. So alphabetically first, we'll go with Sharon Bashan. And if I spell any of your names incorrectly, let me know so I can pronounce them correctly. Sharon Bashan. Okay, we'll move on. Julia Brunelson. Julia Brunelson. Okay, we'll go on. Julianne Felmuth.
Good afternoon. Can you hear me?
Yes, we can hear you.
Good. I'm a Zoom newbie. My name is Julie Felmuth, and for over 30 years, I served as the administrative director of the Center for Public Interest Law at the University of San Diego School of Law. The Center for Public Interest Law, or CPIL, has existed for 40 years. We teach our law students the laws the California laws and federal laws that govern the functioning of state level regulatory boards and departments that regulate business, trades, and professions. Our students actually, they monitor the activities of their assigned boards by attending board meetings. So we have monitored, for example, the State Bar, what was then called Board of Governors, now the Board of Trustees, for 40 years. We've also monitored the medical board, the pharmacy board, the optometry board. You name it, anyone from accountants to veterinarians has a regulatory board, and our students have been at the meetings for many, many years. Our students not only attend board meetings and track what the boards are doing, they also look at what the legislature is doing to the boards and to the professions regulated by the boards. They also learn about litigation affecting their boards, and they write detailed articles about their agencies, which we then edit and publish in our journal, which is called California Regulatory Law Reporter. I was interested to see that Randy actually cited to our journal in one of his handouts for today. I retired a year ago, thank God. So now I have time to be on this, this task force. And it's nice to meet all of you. Thank you.
Thank you.
Thank you. Stephen Fleischman.
Hi, I'm Steve Fleischman. I'm a partner with Horvitz and Levy in Los Angeles. We specialize in civil appeals of all types. My particular area of expertise relevant to this committee is I was on the Professional Responsibility and Ethics Committee for the LA County Bar for about 10 years. And one of my areas of expertise generally is representing attorneys in various types of disputes, but I do have a background in legal ethics and those type of issues.
Thank you. Stephen Hamilton.
Sorry about that. Okay, my name is Stephen Hamilton. I'm a family law attorney in Arroyo Grande, California, located in San Luis Obispo County, and I've had my practice for 25 years. I'm a certified family law specialist, a fellow in the American Academy of Matrimonial Lawyers, and the immediate past chair of the California Lawyers Association Family Law Executive Committee, FlexCom. I am the representative nominated by the California Lawyers Association to this working group. And obviously my area of expertise would be family law. Shout out to Bonnie Hoff, good to see you.
Okay. Amos Hartston.
Yes, good afternoon. I'm Amos Hartston. I see a number of familiar faces, so thank you for inviting me to join this working group. I am a member of the California Commission on Access to Justice, which up until recently was under the umbrella of the State Bar and was started by the State Bar over 20 years ago to focus on access to justice issues. So that is one of the main reasons I'm here. My day job, I work at the California Attorney General's office in consumer law. So I consider myself a consumer protection attorney as well. And other professional experience I have does involve a lot of access issues and pro bono work. I did work for a few years at a legal services organization, Intercity Law Center in LA, focused on housing and homelessness issues, which did involve a lot of landlord-tenant disputes and other housing issues. And for many years before that, I was in private practice at a large law firm, Latham & Watkins, which in addition to my commercial practice, I helped run the pro bono program. So I have experience doing that as well. So very excited about working with you on this working group. Thank you.
Thank you. Dana McRae.
Hi, everybody. I'm Dana McRae. I am a recently retired county counsel for the County of Santa Cruz for a couple of decades. Obviously, the county provides safety net services for the most disenfranchised residents of the county. So I'm familiar with unmet needs from that perspective. I also served for many years on a judicial council subcommittee of the Access to Fairness and Justice in the courts, and went around the state of California seeking information about access to people who identify as gay, lesbian, transgender, queer, or otherwise. So I bring that perspective as well, and I'm happy to be here. Thank you.
Thank you, Dana. Elizabeth Olvera.
So, hi, my name is Elizabeth Olvera. I'm the board member of the California Association of Legal Document Assistants here in California. I received my paralegal certificate back in 2003, worked for a mid-sized law firm in San Francisco for about 11 years. Entered as a file clerk, came out as a trial paralegal with e-discovery background, civil litigation. Then I did a short stint at the district attorney's office under the asset forfeiture, which kind of used my civil litigation, and I learned some criminal. And then before starting my own business as a LDA / paralegal / immigration consultant, and that's what I've been doing now. And now I'm working with the California Association of Legal Document Assistants to further enhance the profession and things like that.
Thank you. Carolyn Chinning. Carolyn Chinning. I think you're muted. There you go.
Oh, okay, great. Hi, Carolyn Shining, and great to meet everybody. And I'm a solo attorney, and I've been a practicing attorney for 30 years. And I started in Illinois in patent law many moons ago, and did that for a number of years. Then when I moved out here to California, I got involved in plaintiffs litigation and represented plaintiffs in complex cases and a number of different things for about 15 years. I've been on my own now for more years again than I want to count. But one of the reasons I came out on my own is I do want to do things like pro bono and help people and volunteer with bar associations. And I got really involved in listening to ATILS, the committee that was working last year that Randy was talking about. And as I got more and more involved, I learned a lot of really great things that could be done here. So I'm here on behalf of the Consumer Attorneys Association of California. I've been a member for many, many years in that group. And so I'm a data wonk. I'm a real geek. So if I get questions, I do a little. I've trained paralegals, my entire career. I love them. They've, so many great paralegals that have worked for me. So I'm really excited to kind of listen to everybody's feedback.
Thank you, Carolyn. Ira Spiro. Ira Spiro. Oh, we'll go on. Judge Erica Yu.
Hi, I left my other meeting early to join us, and I'm a judge in Santa Clara County Superior Court. I've been a judge for 18.5 years. I'm the appointee of the California State Supreme Court. Years ago, I was on at the time it was called the California State Bar Board of Governors. I am a past Manuel Wiley recipient for pro bono work, and was named Pro Bono Attorney of the Year in my county. I have served on the Legal Aid Society board when I was an attorney. For 9 years, I spent time on the California Commission on Judicial Performance, which is the statewide oversight body. It's a constitutional body that has jurisdiction over bench officers to investigate complaints of misconduct and to discipline them, including removing them. So while Carolyn said she's sort of a tech wonk, I probably would think of myself as an ethics wonk. Currently, I serve on the California Supreme Court Committee on Judicial Ethics Opinions, and then I have previously served on the Judicial Council. And I feel kind of like really, I'm behind the 8 ball because you all are experts and know so much. So I'm just really glad to be here. I have done a lot of work with self-represented litigants in the courtroom. We had a experiment in Santa Clara County where all the civil self-represented litigant cases were going to be in one courtroom for a year to see how that would work. And I was the judge who did that, and I loved it. It was just a really great experience, but other judges didn't really want to do it, so it didn't last. But thank you so much for letting me be part of your group, and I'm sorry I have to go in and out today in our meetings.
Thank you. And we'll go back to the top for a couple that may have missed out. Sharon Bashan, and then we'll do.
Hi, everyone. Hi. Nice to see some familiar faces. I'm Sharon. I work at One Justice. We are a statewide support center for legal aid organizations, and we're also an innovation lab on legal services and pro bono. I've also spent 15 years in direct legal services, so legal aid organizations in the Bay Area and LA, both small and large programs. And I would say that I have like a good handle on access to justice issues, the justice gap, and pro bono models.
Julia?
Yes, my name's Julia Brynelson, and I am a professor at American River College in Sacramento. I have had a broad range of practice experience. I've been an attorney for 30 years. I have taught 15 different classes in our ABA approved program at American River College. And as I think I said before, we are the only community college, as far as I know, that is ABA approved in Northern California. There are other private colleges that have ABA approval, but I bring a strong interest in seeing how we might incorporate the community colleges in this discussion, especially since I believe that one of the big impediments to lawyers wanting to practice in areas that have been discussed today has been the large amount of debt that they come out with from these learning institutions. And what's really nice is to be in a program that is able to serve a community college population and to have them have the highest high quality legal education as they could get down the street at a private college. So I think that from the perspective of being someone who has spent 15 years teaching in community college and has sought to really raise the level of instruction so that we could obtain and get reapproved last year by the ABA, it is really important, I think, to look to the options for education as we design whatever proposals we come up with as to how we might best utilize community colleges in this effort. I also have a background of practicing in complex civil litigation as well as legal malpractice defense, where I worked with Kevin Culhane and his law office. And I've also defended other licensed professionals such as accountants and real estate agents in defense of their license malpractice claims. So I look forward to doing work with you, and it's very nice to meet all of you.
Thank you. And then Ira Spiro.
I have been a legal aid lawyer up in Contra Costa County, and I was a public defender, deputy public defender in Los Angeles. I live in LA now. The last 20 years, I've been representing employees in class actions to recover for wage theft. I was on the State Bar's Ethics Committee, Committee on Professional, well, COPRAC, back in the late 90s, and worked with Randy Diefentorum and Lauren McCurdy, who are on this committee. I was also on the the bar's committee on alternative dispute resolution, and I wasn't going to mention that, but then it occurred to me that that's something that this working group should pay some attention to have paraprofessionals involved in well, it's mediation and arbitration mainly. And Julia reminded me of this. Well, I'm the dean of People's College of Law, which is a very small law school down here in Los Angeles, and is fighting for access to justice in one particular way. Our tuition is $5,000 a year, so nobody comes out with any big debt from it. And we are hoping to incorporate some classes, develop some classes, I should say, where our students will do possibly some of the things that we're talking about doing here. That's it.
Thank you. And Chris, will hand it back over to you to start with the Self-Help Center data intro for Bonnie Huff.
Okay. Thank you. And thanks everybody for sharing your backgrounds. This is really a really impressive group. I know we could get something done with this group for sure. It's not going to take us 30 years for sure. Anyway, so is this Lisa? No.
This one's Bonnie Huff for the California Court Self-Help Center.
Oh, okay. So that's going to, okay. So Bonnie, are you ready to go then? Is Bonnie ready to go?
I'm happy to proceed. Hi, good morning, or good afternoon, sorry. I'm Bonnie Huff. I work for the Judicial Council, and I'm thrilled to see this group moving ahead. Just to give you a little bit of background, I've worked for the council for 22 years on access to justice issues to help the courts meet the needs of people who can't afford attorneys. And before that, I ran a nonprofit doing family law and primarily providing assistance on an unbundled basis. And I taught family law for paralegals. So I come to this thinking that we have a robust system of services in California that certainly don't meet all the needs, but lots of areas to grow on. So, and I wanted to also provide a little bit of framework for what's happening with self-help programs in California. California Rule of Court 10.960, which was adopted in the, 2004, provides that attorney supervised court-based self-help centers are a core function of the California courts. And so that has been kind of the primary movement going forward. And courts are committing over $46 million a year for these kinds of services. And we now have over 200 attorneys and over 400 staff paralegals providing self-help assistance in the courts. Every court has a self-help center and often in conjunction with our family law facilitator program. All services are provided or overseen by an attorney with at least 5 years of experience in the case type. And last year there were over 1 million incidents of service in that area. We don't have income, so because it's a court function, there are certain pluses and minuses. But first of all, there are no income limitations, and we can assist and have to assist both sides in a case, because the key function is that the services have to be competent, neutral, and unbiased. So that's our core in terms of providing assistance. Most of the litigants coming in for assistance are making less than $3,000 a year. And if you're looking at the Justice Gap study, 10% of the people who received assistance received it from a self-help center, court-based self-help center, and 16% of the low-income people received it from court-based self-help. And we're my team is going to be kind of looking at that data a little bit more and trying to understand it in terms of what types of services, what kinds of things were going on. The kinds of services that are provided in court self-help centers are interview and assessment, assistance with pleadings, fee waiver applications, document review, procedural information, including and but not limited to explanation and clarification of court orders and the process by which to obtain, enforce, and modify orders, assistance with understanding service requirements and methods, preparation for hearings, completion of orders after hearing and judgments, and drafting stipulations. Most also provide some kind of mediation or other settlement services, readiness review for calendar appearances, case status meetings, and courtroom assistance, which is not providing representation, but answering questions, explaining procedures, and doing sort of oftentimes sort of mediation on the side. So some of the limitations are, as I said, one is that it has to be neutral, it has to be unbiased. We're only dealing with state court cases for the most part, although certainly in the smaller jurisdictions where there really are very few attorneys, they do kind of whatever comes in the door, right? I was just looking, there's some bankruptcy, there's some maritime law, there's a whole variety of things that people come in with questions, and they try to provide at least some guidance and direction. But the vast majority of the cases, as shown, are in family law, dissolution, child and spousal support, child custody, and others. That is in large part kind of historical, but it also reflects what's going on in the courts and what the needs are of people, because in order to get a divorce, you have to go through a court process where if you have a contract dispute, you may or may not want to get the court engaged in the process. So that's, I think, one of the things that happened. And our program started in 1997 with the Family Law Facilitator Program, which was designed initially, it was designed to assist with child support. And the courts started recognizing that, and it was, we had to work out a number of ethical issues with the bar in terms of how attorneys were providing assistance to both sides. I remember having a wonderful conversation with Bob Hawley, where he was sort of saying, so the court is endorsing ghostwriting and the court is the ghost. We're like, oh yes, that's kind of what's happening in many of these situations. But it's a huge access to justice issue and need. So that is just a huge portion of what's happening. As I said, started with child support. Once the court saw the benefit of having an attorney who could help prepare the pleadings and get things together, it expanded into other areas. So in addition to family, we also do, there's a lot of guardianship. And landlord-tenant, small claims, domestic violence and other restraining orders, including civil harassment, name changes, and basic probate. The other area where there is not, we can't provide assistance really is in administrative processes because those are not coming before the court. A couple of other areas that I think it would be useful to be aware of is that the courts have developed free document assembly programs that where you kind of like TurboTax, you enter in your basic information and it prints out forms. They range from form sets with 4 pieces of paper to form sets with 75 pieces of paper, depending on the complexity of the procedure. And so I have data for one of them, over 200 form sets are completed each year at this point. Divorce, and the case types are divorce, domestic violence, child support, guardianship, conservatorship, landlord-tenant, small claims, and name change. And that is, I think we're going to see a real growth as a result of more remote services with the pandemic. And another piece of this that may be of use to you is that we also have Justice Corps members who are college students who are commit 300 hours of time to work under the direction of attorneys in the self-help centers. 275 of them are the 300-hour workers, and 44 are graduates who were really successful as Justice Corps members and come back and do a full year, do a year of full-time service as an AmeriCorps program. And that is, in many ways, they are often teaching workshops. They're helping people who just need additional time and assistance. Most of them are multilingual, and so they can also provide assistance in other languages. But for those people who just need somebody to sit with them as they're trying to fill out the forms and understand basic concepts, they can do that and then have the forms available for review. Another piece I think that's important to think about with family law and with this issue is we're working on a big cost benefit analysis of court-based self-help, and I've also managed the evaluation of the Sergeant Shriver Civil Council pilot project. And what I see when I'm in courts looking at family law pleadings is that it's very hard to find any pleading where somebody didn't get help. It's very clear that most pleadings are being done either in self-help, by unbundled attorneys, or by, I assume, LDAs. And I think you see more LDA usage in the rural communities, but in terms of form completion, there's a lot going on, and I look forward to hearing more from our LDA colleagues and folks about that. But their document preparation is largely underway, and I think these document assembly programs help with that. And we have worked over this 20-year period to try to make the system work better. So we are looking at courts where 90% of the family law filings have at least one person who's unrepresented. But we've really tried to set up the system so that as long as you can get your paperwork done and you don't actually go into court for a hearing. Child custody goes into a mandatory child custody mediation program that's paid for by the court. Child support cases, the local child support agency provides assistance at no charge. There are other kinds of issues, and I'm not saying it's all of it, but I'm just saying that we have set up a procedure where you can do default with a stipulated agreement, and as a way to minimize filing fees for litigants. So there are a lot of procedures that have been developed, and we have worked hard on judicial education particularly in the family law area, to help people who don't have attorneys manage through the system by asking questions, by directing how the conversation goes, those kinds of things. We worked closely with the bar and with Randy and others on developing rules regarding limited scope representation or unbundling back in 2001, because we recognized that there were issues that were not really appropriate for self-help, and where people needed additional assistance. And as I heard Mimi talk about the issues that have been sort of carved out as not appropriate for paraprofessionals, there are things like complicated property issues, houses, taxes, if there's bankruptcy involved, stock options, pensions, those kinds of issues. And in custody, things like move-aways. So, and there are clearly people who need additional assistance, but there's, a lot going on.
Bonnie,
yeah,
I think Amos has a quick question for you.
Sure, please. Mm-hmm.
Oh, thank you. I didn't mean to interrupt, but thank you, Bonnie. I am a big fan of the self-help that happens at the courthouses and everything that's been happening with that program for many years, and hopefully it can be even further funded and expanded, and some of these navigator ideas can be done through self-help. I'm very interested in the context of this. Mm-hmm. How much has it been a limitation or a frustration for self-help at courthouses to be limited to providing information as opposed to legal advice, or this sort of divide, which may be artificial, but it's intended, I think, to be a bright line in terms of actually, providing representation or providing legal advice, which court forms to fill out, which box to check on the forms, in addition to general information about, where to go and what to do and where to find resources.
Well, We have guidelines for the operation of self-help centers, and they actually do not say that you can't give legal advice. What they say is that the information has to be competent, neutral, and unbiased. That said, there's certainly, I think that's the not legal advice is an easy divide for people. And when I train, I say that I try to put myself and think about if the other person were sitting in front of me, would I say the same thing? If I had both parties in front of me, would I be providing information? And that is extensive, detailed information. So most people who walk out of self-help centers have their forms completed and they've been reviewed by an attorney. And so it's not just, here's the form, hope you can fill it out. It is in either through a document assembly program. So for example, what LA does is they have an initial workshop for divorce. And they run it, I think they run 100 of them at different centers in English and Spanish and Armenian. And they go through, the first workshop is just, here's all the information about divorce, and here's information, you start filling out a form so that you can go home and get everything together. And then you come back and using the document assembly program, you're going to have all your pleadings completed. And I will say, having reviewed those pleadings, those look as good and sometimes better than pleadings I've seen attorneys do because they're just comprehensive and useful. That said, I think it is where we're really facing more challenges is as we try and go into areas where there's more need for things like points and authorities, which require strategy, which I think we don't see a way to do effectively unless it's here's sort of a form, points and authorities that gets developed. And there's just a huge challenge with cases where the other side is represented, right? And where we see the challenges and why we really, we're pushing on limited scope, and this may be yet another solution, is what we can't really do is negotiation on behalf of there's the court appearance, but there's also the negotiation. And in doing the Shriver review, I looked at hundreds of unlawful detainer files in LA. The answers were fine. Coming out of self-help center, they were awesome. I couldn't really, partly because it's the same people who were doing them as the attorneys representing in court. Where people were crashing and burning was at the negotiation, because most of those cases settle, they're settling day of, and there's an attorney on the other side. And while I think we can provide good information to people, I think we can provide better information to people about what they can expect, how to prepare, what their issues are. I think it's very hard for somebody who is going against somebody who does this for a living. Does that have to be an attorney who is doing that? I don't know, right? But I think that there's this huge kind of negotiation piece that is that I don't see court being able to do, at least in terms of representing. I think what we have are a lot of programs where legal aid comes in and can provide that kind of negotiation. We do a lot of settlement where we're trying to assist both sides to come up with an agreement. But calling the credit card company and saying, hey, are you willing to deal with this debt is really a challenge. And we have been trying this year to move much more into civil case types at the direction, but because that was identified as an issue by the Future on the California courts. And it's hard. So if you file, for example, is this somebody filing a response in a debt collection case? Not that complicated to do, but they're going to get hit with a whole bunch of discovery next week. And that's going to take time for the person, to get together and to realize they have now a really tight deadline, trying to explain how to respond to a request for admissions, trying to do all the discovery things. It's been really hard. And legal aid's, again, legal aid has figured out how to do it, but it is a much more complicated thing. And as I say, without the ability to pick up the phone and say, are you willing to take this amount of money? Right. To my mind, we're trying to teach people how to do that on their own, but I don't think we have a lot of data on how successful that is yet.
Thanks, Bonnie. We do have another question for do you want to continue with the presentation and then we'll have Stephen jump in? Or do you
I'm
want to take
fine
the
with
question?
whatever. Go ahead, Stephen.
Hi, Bonnie. My question is specific to unlawful detainers. Could you sort of walk us through, for the average defendant and an unlawful detainer who can't afford counsel, what your programs can do and what they can't do? You sort of touched on the negotiation aspect. I assume at trial they can't represent the defendant, but could you walk us through that process of what you can do and what you can't do along the way?
Okay, sure. So, so first of all, if there is, one of the things self-help tries to do is if there is a legal services program or other provider out there that can provide full-on representation, that referral will be made, right? We want to get people to the best possible resource for them. But generally, they're doing an answer, right? They're helping somebody fill out an answer, get it on file, and get it served. And then preparing, there have been different models of classes, you know, sort of like, let's walk through what an unlawful detainer hearing is going to be like and let's practice. There are tip sheets on how to do negotiations. There are videos on what the process is going to be like and how to prepare. So those things can all take place. And you can also have a mediation program or negotiation program at the court where, again, but it would not be that there's a court person standing next to the tenant. It would be a court person working generally with two self-represented parties, working things out. So most courts, for example, Los Angeles, if there's an unrepresented landlord and an unrepresented tenant, the court provides a mediator day of to try to resolve it. And one other thing that I think has been interesting about self-help that I don't know that people realize, but we serve an awful lot of low-income landlords as well. So it's not the kind of thing that you think about, right? But there are lots of people who are subletting a room in their home to be able to make their rent or to be able to make their mortgage or whatever, or they've let somebody come in and stay with them at no charge to be nice. They may have elderly children, but I mean, they have older children, right, that have come back home and they don't have a way to, even as a tenant, as the master tenant, they still have to go through an unlawful detainer proceeding. And the legal aid has not been providing services in that area for the most part, except for some senior programs. And they don't have $1,000 or $2,000 or whatever to actually file their case. So it is an interesting area where we've identified that it was a need that I don't think, I will say when we started having to provide the service, I was like, I don't know that there's going to be much of a need. It was an issue to make sure that we were providing free, fair, ethical services to both parties. And I know that in the Alameda, it turned out there was a large population of folks who had bought their houses during the Second World War, who had somebody in the house that they needed to evict and had no way to do it before.
Thank you.
And then I just wanted to address one of the questions that was raised earlier, which was a great question, was about how legal aid organizations work. And we work closely with legal aid organizations that are providing self-help in the courts. The data I'm providing is about the court staff. But there are many wonderful legal aid programs, and BetZedek, which is one of the programs you mentioned, actually does provide assistance, I think actually every day. It's actually now housed at the law library across the street because the self-help center was pretty darn busy. But they have done an evaluation of their program, and 75% of the conservatorships in Los Angeles are handled by this program, by their self-help program. And 90% of those are successful, which is remarkable since they assist both sides. And they are supported by a document assembly program, the TurboTax thing that I talked about, that was developed by the Judicial Council and
filling out the forms used to take them 4 hours, and now it takes them 15 minutes. So they're able, again, to have high quality documents that are ready to go, and they can use their staff and volunteer attorneys. I think they do that with two full-time equivalents to do 75% of the cases in Los Angeles. So they, the attorneys then can spend their time explaining the process and providing answers and, you know, being kind, rather than just focusing on filling out the papers. So I think that's primarily it. But again, you know, so I think we all need to I think the data is incredibly important. I really look forward to hearing from people on the ground in terms of what they're seeing. I know that even though there are all kinds of free programs to do taxes, people still go to H&R Block to do their 1040 EZs, and that's a great service, right? But I think we're a little different. So for example, Oregon does have a network and Washington State both have self-help programs, but they consciously decided not to have them run by attorneys on the theory that non-attorneys wouldn't provide legal advice. And they're much less robust, shall we say. And California has certainly the largest network and the most commitment in terms of staff and other services for these kinds of programs.
Bonnie, I think Leah has a question as well.
Sure.
Leah?
Sorry, Bonnie, I think you kind of touched on it there with your closing comments, but we've got this data up on the screen, which just shows, you know, the encounters in person at the courthouses and then on the website. And I think what you're saying, certainly in the pre-conversation we had, and I just would love for the group to hear it, is really that in the case of the self-help center sort of input into the selection of topic area process, this context that you're providing is kind of really critical, as opposed to just focusing on utilization data. Because it sounds like, for example, with respect to family law in particular, that there has been a tremendous amount done in California to provide resources in that area. The one issue you have flagged for us is the in-court representation is missing. But aside from that perhaps the needs are being met in these other ways. And so I just wanted to make sure that you had the opportunity to really give your sort of direct thoughts and suggestions as to topic areas. And because when we look at the utilization in self-help, it's very concentrated in family. We see that other states have chosen family as an area, and I just want to make sure you share your thoughts.
No, thanks. Yeah. Well, I mean, I think it's both the in-court and the negotiation, because I think that is, you know, a huge area for people who, it's why we provide settlement assistance at the courts, because there's traditionally a meet and confer requirement. And the reality is, if people could have met and conferred, they wouldn't be in court to begin with, right? It's a very hard thing to do without some level of assistance. And the fear that people have a lot of times is great, whether it's negotiating with the child support agency or trying to work out the exchanges for custody and visitation, other kinds of things. So I think definitely in court is an issue, particularly if one side is represented and the other isn't. I have cautions about, I guess, in terms of, we did research on how litigants do when they're both unrepresented in court in family law, and they basically understand the proceedings. They're able, and again, this was with judges who were willing to be videotaped during it, and litigants who were being able to, you know, who were videotaped. But people did pretty well. Where it all fell apart is if one side had assistance and the other didn't. And part of it is it was very hard for the judge not to start speaking legal speak, right? That and judges are much more conscious at that point about rules of evidence and concerns that attorneys may have in that kind of situation. So I think whatever the committee comes up with, I would encourage it to consider the importance of making sure that the services are neutral. That I've looked at the Arizona model where services are only going to be provided to DV survivors. And I can see that could be enormously helpful. But I think from the DV community, we know that many, many people who are the respondents in those cases probably should have been petitioners, but also really need help. And setting up, so I think whatever this committee does is, I think, to set up systems that would provide neutrality. But there are a whole lot of other, I just also want to say, there are a whole lot of other case types. As I say, as we're moving into civil, we haven't done much in civil. And there's a lot of caution about, this goes back to Amos's questions about the sort of advice issue, very cautious about helping people file a civil case. We don't have the forms, choosing venue, choosing the causes of action, all that kind of stuff definitely feels like legal advice at a level that programs are not comfortable with. Responses are a little easier, and discovery, other than the challenges in time and how to do it, it feels less, anyway, less, I don't know if it's biased but I think there's more of a neutral feeling. But I suspect that there's an awful lot of cases where people simply can't afford attorneys for limited civil cases for things under $100,000. And that's real money for people. But they just don't have any way to get into court. And some of that, we see the numbers from Becky Sandifer about people who choose not to get legal assistance. And I think part of it is because people do know that lawyers are expensive. And if the amount is at a lower level, they're, sort of like, why would I spend that kind of money if I may not be able to collect it, or I don't have the bandwidth to do that kind of case. But I think that we have not touched the surface of civil case types and the needs there. And I'm sorry, you also asked, as you talked about with the analytics from the self-help website, we do have over 4 million people a year, individual users, who come to the self-help website. And it's designed to be step-by-step through the processes. And again, we're much stronger on the family side and other areas. And we've been trying to write, and I think we're strong, pretty decent on landlord-tenant, but we're in the process of trying to write a lot more civil content and also be much more mobile enabled. But it's challenging. It's challenging stuff. So it may be an appropriate area to be considering.
Thanks, Bonnie.
Thanks, Bonnie. Okay, any more questions for Bonnie? If not, we'll turn it back over to Leah. I'm sorry.
Chris, this is Erica Yu. I just wanted to add something to what Bonnie said. I definitely agree with her that there's some potential in civil, partially because people often ask, bench officers for referrals, and we give them a list of lawyers in certain areas. And there are people who have what seem to be grounded civil personal injury claims, for example, but they're so small that a plaintiff's attorney wouldn't necessarily want to take it on a contingency fee. And the person really needs some assistance negotiating with a claims adjuster or some in-house adjuster, and they just don't know what to do, and so they might not pursue that claim at all. But if there was a paraprofessional who could help them, it might give them more access to and a road to recovery on those types of cases where generally lawyers aren't going to take them, but there is something there for that person.
Thank you.
Yeah, and I guess one other point, there was a New York program that unfortunately has ended. Some of the Navigator programs, they were very, very different. But one of them used social workers as navigators who would be at the courthouse to help people with their, mostly with negotiations with the landlord. And they had incredibly high success rates as far as avoiding eviction. And part of it is, I think, if you're in court all the time and what's possible, but you're also trying to get other resources and maybe have access to be able to pay the landlord some of the back rent or other kinds of things. But that was, I think, one of the more successful navigator models that allowed non-attorneys to be providing negotiation services.
Thanks, Bonnie. I think Sharon has a question now.
Yeah, hi. If you look at low-income folks and the services that are available to them, and you look at that on a spectrum, so self-help being one end, going up to legal advice, going up to brief services, and then going up to extended services, they're most likely going to access self-help and least likely going to access the ability to get extended services. And that's just due to lack of resources in the legal aid sector. But oftentimes the extended services are really what's needed for long-term change and ability to get out of poverty. I would just like this committee to really consider how paraprofessionals can fit into the scheme, whether it's unbundled services on the extended services side, or doing some of the other types of services like brief services, so that it frees up more legal aid attorneys and pro bono attorneys to help with extended services.
I think those are really important points, Sharon. I think the other thing that is a benefit for self-help is that we do not ask about immigration status, and because the California courts are available to serve everyone, and we have, there are federal limitations on some of our legal aid programs that makes that really difficult. So I think that's another area where I think we need to be really mindful of the challenges that low-income immigrants have in accessing justice.
Thanks, Bonnie. Any other questions for Bonnie? If not, we'll move to the California attorney practice analysis with Leah.
Great. Thanks. Russia, you can go ahead and advance the slide. So another input for this group to consider in terms of the selection of practice areas for our licensed paraprofessional program here is the California Attorney Practice Analysis, or a job analysis, which was just recently completed. Many of you may be aware that the State Bar launched really transformative studies of the bar exam in 2017. There was a standard setting study, otherwise known as a cut score study, and a content validation study. In addition, a study which looked at changes, really declines in the bar exam pass rate that had been the impetus for the studies that had been initiated by the Chief Justice, in fact, in 2017. So that performance changes study is looking at what are the reasons, the causal factors contributing to declines in the pass rate. So those 3 studies were done. But importantly, that content validation study completed in 2017 relied on a job analysis that was done in 2012. And that job analysis was completed by the National Conference of Bar Examiners. Until this year, the State Bar of California had never conducted its own job analysis. And we know now from really immersing ourselves in best practices in testing and licensure, and great partnerships that we have now with the Department of Consumer Affairs, frankly, that best practices in testing and licensure suggest that job analyses need to be done every 5 to 7 years. Really do a large scan, lay of the land in terms of what the profession looks like, what new practitioners in the profession are required to know and know how to do. And that's really the gist of what a job analysis is. So the State Bar launched its own for the first time in its history, and you can advance the slide, Russia. So I've gone over some of this, but the purpose of a job analysis is ultimately to ensure that the exam content is related to what new attorneys need to know and know how to do. You use the job analysis ultimately to reaffirm or modify the subjects that are tested on the exam, the skills that are tested, and the format or the construct of the exam. You can move forward. In California, we employed two different sampling methods, two different really survey methodologies. One was the traditional survey, very well established for practice analyses. This is, your standard hundreds of question survey that attorneys were asked to complete. It would take them about 1 to 2 hours to complete the survey, asking them to reflect on their practice. The next is an ESM survey, experience sampling methodology. This is a very new to deploy in a job analysis setting, what we did in California. Basically what it does is it pings attorneys or respondents and multiple times throughout the day and asks, what are you working on now and what skills are you employing, among several other questions. So because of this approach, you get real-time data rather than sort of reflective data looking back on what you think your practice consists of and what you think you do. It is a different modality as well in that the ESM survey component lasted for a 2-week period as opposed to the one-time approach with the traditional survey. Combined, we got about 16 to 17,000 responses from unique attorneys out of California's 195,000 active attorneys to both surveys. So what did the data tell us? The data shows us the kinds of tasks and legal topics performed by different types of attorneys. When we say different types, we're looking at practice areas, practice settings, years in practice, and the depth of knowledge required for the proper performance of the tasks, how the level of complexity relates to the depth of knowledge, and how critical the particular tasks are. And the criticality is an important one. It's determined or it's measured by the degree of potential harm to a client if it's performed incorrectly. So you can go to the next table. So what the California job analysis or practice analysis was guided by its own working group. And that working group ultimately decided to do a composite rating between that ESM data and the traditional survey data. I mentioned there were two different surveys methodologies employed. For the ESM data, the working group selected from the ESM data frequency statistics. So how often was, in this slide you see, a particular legal topic actually being worked on. It's pretty obvious, I think, why the working group chose to use the ESM data, because that's real-time data from many thousands of attorneys giving us these frequency scores. On criticality, the degree of harm if performed incorrectly, the working group chose to take that data from the traditional survey, thinking that when attorney respondents had time to reflect back on criticality, that the reflective data would actually be more accurate than any given attorney's sense of criticality in the present moment of responding to a survey. So in the far right, you see the composite score. And what this is really telling you, the gist of it is, things at the top, high frequency, high criticality score, meaning there is a significant potential degree of harm if performed incorrectly. Things down here in the bottom of the chart, lower frequency, lower criticality. So you can see the lowest one of all here, secure transactions, and taking you up through real property, estates, and trusts. And so I'll just pause there and let me see now if people have any questions, because I know some of us have been looking at this data for a long time, that if it's your first time seeing it, it might be confusing. Any questions? All right, I don't see any. We can move on, Russia. So next, this is the same scoring criteria or composite scoring, but for tasks. And recall, I think a couple times in this meeting so far, we've emphasized that today we're really trying to focus on practice areas. This task level data is available, and I want you to know that when we come back to tasks with your group, which should be at the next meeting, we can dig into this competency scale again at that time, but it's laid out in the exact same way. So what are the high frequency, highly critical activities versus the lower frequency, less critical activities or tasks, again, that attorneys are performing, and this is their own rating. I see Carolyn, your hand up.
Carolyn has it. Oh, you got her. Okay.
Yep.
Carolyn?
Okay. Yeah, thank you, Leah. Because I read this before and I was very confused about these two charts. And I guess there's a concept called risk benefit where things are high risk, low benefit, low risk, high benefit. The odds of getting into a car crash where it's terrible and horrible is low, but we want to prevent that because it's a very high risk. So in the chart before, I haven't looked at this chart, but you have tax down there, and if you mess up a tax case, it could be devastating for someone. They could go to jail. So I'm just sort of, some of these, I wonder about the methodology in terms of how attorneys were asked to think through this, because this doesn't, the criticality part of it, I don't know why some of these things are, maybe that just not enough people did it. I don't know. This chart really kind of gave me pause, and now that I understand it, it doesn't help. But maybe you could speak to that. Some of these things on the low criticality seem really important to me.
Well, it's important to know that the methodology was not just to rate the criticality of the entirety of the legal topic area. In fact, nobody was asked to rate the topic area in and of itself on a criticality scale. Instead, underneath each topic area or associated with each topic area were many, many tasks. And so attorneys were rating the criticality of the associated task. And what it may be, and I'm not looking at the data, and I'm not the best person to opine on this, frankly, but we can get you this answer. It may be that the bulk of the tax-related tasks that were being performed were low criticality tasks in the eyes of the respondents who were completing the survey. That being said, there could very well be very high critical tasks under tax. It's just that they weren't being performed that often during the course of the survey. So, and actually because we took criticality from the traditional survey, that is slightly different. It's not really what happened during the course of the survey, but thinking about the composite overall practice of tax and the relative distribution of those tasks, it just may be that people felt that there are more low critical tasks than high critical tasks, and that's why overall you got a lower rating. But we can certainly get more information on that for the next meeting.
Yeah. Thank you.
Can advance, Russia. Had one more slide I wanted to show you. I mentioned that in addition to looking at frequency and criticality, the CAPA analysis also looked at depth of knowledge required. And so this knowledge rating, the scale you can see there on your screen, number 1 is the lowest level of knowledge required. This is a very traditional taxonomy in educational settings. The number 5 is the highest level, synthesizing and evaluating information versus recalling information. So if you look over to the right, you can see in depth of knowledge, first of all of the legal topics surveyed in the California Attorney Practice Analysis have over a level 3 in terms of the DOK required. So we really don't have any truly low level knowledge requirements. But if you look here, you see at the bottom, professional responsibility, and then moving up, you see estates and trusts, business association, family law, finance, etc. You can read it for yourselves. So when we move in just a few moments to the brainstorming section of this meeting, you're gonna see lined up the CAPA legal topic results, the practice analysis results, both with that frequency and criticality composite rating, and with the depth of knowledge rating. So in terms of options for things you might consider in terms of practice area selection, these data points derived from CAPA are really just provided to you so that you can have an understanding of what our most recent and really only California job analysis tells us about frequency, criticality, and depth of knowledge required for various legal topics being performed in California. And this slide is just summarizing what I said in terms of how the group may use the data. Okay, if there's no more questions or comments, I'll go into the last sort of input for your consideration today. So we've tried to give you a lot of input here. You've heard about the history of California's efforts in this space, a 30-year history that Randy went over fairly quickly. You've heard about what other states are doing in terms of licensed paraprofessionals, our own California Justice Gap study data, what that suggests in terms of need in particular topic areas, input from the self-help centers and Bonnie and all of her incredible experience there, the practice analysis, and now lastly, we're going to move to ADLS. This is the Access Through Innovation in Legal Services Task Force that's been referred to several times on this call. Really groundbreaking work done by the State Bar to take a look at regulatory reform broadly and how regulatory reforms might increase access to legal services. The original impetus and I think original thinking around this work, the work of the task force, is that it would be very tech focused. So really looking at tech and even AI delivered legal services. To do so would of course require significant changes to the rules. It turns out that this group expanded its own sort of beyond what its charter originally contemplated and really explicitly ended up recommending the establishment of a licensed paraprofessional program as part of the continuum of efforts that should be made to increase access to legal services. Understanding that the Board of Trustees had also established this working group, the ADLS final report included explicit suggestions for this working group in a number of areas, including the selection of practice areas, if you could go back, the selection of practice areas for participation or inclusion in the program. And so those recommendations are listed here. So first, the ADLS task force recommended that this working group make its decisions around legal topics to be included in the program, make those decisions informed by data from the Justice Gap study and the Self-Help Center data. In addition, that your decisions would be informed by the practice analysis. And so you see today in the presentation, we have heeded to those recommendations and made sure to provide you with that information. In addition, and I think this is an interesting one, the ADLS recommendations really urge this group to maintain flexibility in its approach, not to have a definitive exhaustive list of legal topic areas. There is a rather lengthy, but I think impactful section in these recommendations around name changes, work that has sort of really significantly increased over the last several years as we as a society have become more comfortable with concepts of transgender and changing one's gender. And so that was an example of a kind of a need that's out there in the community that maybe a working group like this wouldn't necessarily explicitly identify, but we don't want to create a structure that precludes some kind of ability to be responsive to these needs as they arise. So maintaining flexibility, another important component of the recommendations from ADLS. And with that, unless there are any questions, I can turn it back over to you, Chris, to initiate our brainstorming session. Oh, I have two questions up.
Okay.
see Amos's hand.
Thank you for that summary. I think it's very helpful to see what the prior working group did. I understand, although I don't have a lot of information about this, that the moving forward with this working group and specifically about practice of law or legal advice by non-attorneys was very controversial in the last working group, and there was a lot of public comments. Are those available anywhere on the website, or is there some sort of summary of what the comments were about this in terms of what the public has already sort of commented on what the fraud issues or other, ethics or attorney-client privilege? I know there was legal services made comments, and I think it might be interesting to review some of those, although I understand there's a lot of them, so I'm worried about getting all of them, but I'm interested to know if those are available or if there's some sort of summary of them.
Yes, both. The actual comments are available and a summary of the key themes from the comments. And so those are posted on our website associated with the meeting agendas, the Board of Trustees meeting agendas where they were presented. But we can certainly send that out to this group. Amos is referring to there were several thousand public comments received in response to the issuance of preliminary recommendations by the task force, including with respect to the specific issue of creation of a limited licensed paraprofessional. So we can provide you with all of the comments and then with again, the summarized set of comments. I think that discussion will be particularly relevant when we talk about regulation, although I agree, certainly there were very consistent messages and concerns raised about including immigration as a legal practice area that would be allowable or authorized under this program. So we'll provide all that data, and thank you for raising that, because immigration certainly was flagged by many respondents. I do want, or many folks that provided comment, I do want to say that one of the flaws, I think, of the ADLS process, admittedly, and something that on the staff side we really tried hard to address, that the vast majority of comment received was not in fact from the general public, but was from attorney licensees. And that is a really critical body to hear from, but it is not the public writ large. And so we did make an attempt to survey citizens about some of the reform recommendations that were being considered using the University of Chicago that completed the LSC and the California Justice Gap Studies. And that data is also available, was provided to the Board of Trustees, and we can provide it to this group because it's interesting to see how kind of the common potential consumer views the harms or relative harms and benefits of some of the reforms being considered.
Great, thank you.
Sharon?
Hi, Leah. Thank you for a very informative presentation. My question is not so much about the presentation, but I hope you give me some leeway as I ask something that I think is very relevant. With COVID right now, and with JDs or to-be JDs who are going to be graduating, I know that the California Bar so far has chosen to either cancel or delay the bar exam. It did not take the path of New Jersey. I also know that there is a percentage of those to-be JDs that would be interested in lessening the justice gap. Is there any discussions going on that you're aware of about letting people practice in a limited scope until they can take the bar exam?
I'm going to let Donna answer that. My understanding there has been plenty of discussion on that topic.
Yes, there has been. So as a preliminary matter, just to sort of lay out the responsibilities, the State Bar is an arm of the Supreme Court when it comes to the admission to practice law. And so the Committee of Bar Examiners evaluated the various options about the bar exam. Then the Board of Trustees evaluated the various options about the bar exam, and the board provided a recommendation to the Supreme Court. The decision is ultimately going to be a decision of the Supreme Court. The recommendation that was provided by the Board of Trustees, the preferred option that was identified was to delay the July bar exam to September, and to conduct the exam in September either in person, online, a combination of both, based on what is possible at the time. The bar also recommended to the court that simultaneously, if that is the option that they select, to prepare for the possibility that maybe an online or in-person exam cannot be given in September, that there be a working group that's convened to develop a to identify rule changes that would be necessary to create a provisional certification program. So something sort of like the practical training of law students or the certified law student program that currently exists. This would exist for people who would otherwise be eligible, who've met all the criteria for admission to practice of law, except for the taking of the bar exam. And so it would provide them something lesser than admission to the bar, but something greater than what you would get as presumably a certified law student. And so that's included in the primary recommendation that the bar submitted to the court. And we certainly expect that we'll be hearing the results from the court's discussion by the very end of the month.
Thanks, Donna.
Mm-hmm.
Any more questions for Leah on this part? Okay, so we'll move to item 6, the brainstorming area. And just to kind of set the stage for this and remind everybody, I think on the second slide, back at the very beginning, we talked about the working group introductions and roadmap. And I think one of the sections was on practice areas and tasks, which we have to present to the State Bar Board of Trustees in September. So for the next month or so, the working group will be looking at, that's one of the areas that we'll be looking at and presenting the concepts and recommendations for the practice areas and tasks. So just something to keep in mind. So we have a couple months to look at that. And I think I'll turn this back over to Leah. Will you be leading this part on the brainstorming part, or how do you want to do this as we look at the different approaches? And
yeah, I'll introduce it, and then hopefully it'll just be good group conversation.
Okay.
And what I did want to add is, in addition to having a couple months to work on this, if the group today settles on some practice areas, at least for preliminary consideration, and our hope is that you do, then we plan at the next meeting to invite some practitioners in those fields to come and talk to you more specifically about what that might look like or what that might entail. So we just wanted to provide some options for frameworks around how to select practice areas. So one option would be to align the practice areas selected for California's program with those authorized in other states. Another would be to align with the findings from the California Justice Gap Study. Another approach would be to align with the Self-Help Center data, but also, very importantly, the experience and the context that Bonnie provided. Another approach would be to align with the CAPA findings, and what that means specifically is that you would not choose, for example, high frequency, high criticality topic areas. So if you move on, then lastly, and it goes without saying, there's an approach that is none or all or some combination or some hybrid. So what we tried to do in these last couple slides is very succinctly give you the information that you need associated with each of those options. So here on the screen, you see for the 4 programs where there is something fairly robust underway or being considered, what the practice areas are that are included, and where there is an additional area or areas under consideration, we've identified that as well, as you can see for Washington and Utah, I believe. So if you want to move on. Here, the Justice Gap Study findings. We went over this, the top 3 legal needs of all Californians. The next 2 chevrons reflect data for those under 125% of poverty and the other over 125% of poverty. And you can see at the top of the chevron, the top 3 areas where legal help was sought and received, versus at the bottom, the top 3 areas of severe impact as identified by respondents in both of those categories. Then if we move on, self-help data, we've got the customer encounters, website hits, and the feedback and context from Bonnie about what would be valuable and what are important factors to take into account. And if you move on, from CAPA. So there on the left, we've got the knowledge domains requiring the lowest depth of knowledge. I have professional responsibility in brackets there or in parens, because interestingly, professional responsibility is very high up on the other frequency and criticality scale. So it's one where there is not great alignment between those 2 sets of criteria. On the right, you've got knowledge domains with low frequency, low criticality. And with that, we just really want to open it up to the group. You know, our charge is to identify practice areas for inclusion, at least the preliminary thinking. We've provided you with a lot of possible frameworks for making that decision, and really just love to hear from you. I think I see Stephen Hamilton has his hand up.
I do, thank you. Is there a possibility that the end product of this is that we would do a pilot program that might be restricted to a subject matter area, but also will only be tested in one specific geographic area, so we could get kind of I think it would be easier to collect data on the efficacy of the program and what needs to be fixed before it's rolled out statewide. I'm thinking it's probably would be an 18-month period of time where you spent 6 months doing the additional education in a county where there was a sufficient pool of candidates that could be whatever we're going to call them, but the paraprofessionals, and then a year to observe what happens in that county and then implement it. I know it's an 18-month delay, but they've been on this for 30 years. So would that be feasible?
Certainly. I mean, the working group is going to be able to make whatever recommendations you can all agree to. And in terms of implementation, I think piloted implementation or limited scope, to use that phrase, implementation certainly contemplated and a reasonable approach to consider.
Thank you. Oh, and one other thing too. Are we going to get the slides from today?
Yes, we can send those out.
And I was going to ask if I do slides all the time, and sometimes I'm finishing in like an hour before I'm doing a presentation. But if we could get them the day before, so we could actually, like there's been times I've wanted to go back in the slide, but we can't do that if we don't have a copy in advance. Thanks,
Okay.
Marsha.
All right.
All right, Hamilton out.
Ira?
Yeah, as far as pilot studies, do you think it's possible we could have multiple ones in different subject areas, maybe in different locations too?
Okay.
Do you think that is possible, Leah?
Oh, is that a question? I thought that was a statement.
Yeah, sorry. Yeah.
Yes, as I mentioned, I don't think, certainly not at this juncture, that the group should be limited in its thinking on the implementation side. I think the board, and Chris or Debbie jump in if I'm speaking out of turn, but I think the board will welcome your best thinking about the program, including how to roll it out and evaluate it. And if a phased rollout is what makes sense to the group, then I think that should be recommended.
Yeah, I agree. I think we want to be creative and get your best ideas. And if that means we try a couple different options, then yeah, I think that's something that we would want to consider presenting to the full board.
This is Debbie. I think that the board, I agree with Chris, we'd appreciate your best thinking on all of it, and a wider scope. We don't have time. We don't really have the ability to dig like this group will be able to dig into the subject matter. And so we appreciate however broad it is, to give us a good idea so we have the information that we need going forward. So yeah, I don't want to say blue sky, but just sort of give us your best effort. I think that's what's important.
So in terms of the practice areas, any thoughts? Maybe Russia, would be helpful to go back to the first slide with the other states.
This is Julia, and I have a thought. Just, I don't know if it's looming on the rest of you like it is me. I know all of our lives changed overnight this last month, and as I'm teaching now from home, and I'm thinking about the needs that I've been seeing and the struggles that I've been seeing with some students, specifically because of the pandemic. I think the items that have been traditionally identified as subject matters are actually going to be probably even more pronounced now. And I think that once we look at what happens financially to our entire population, once we see what happens medically to this entire population, especially when you're thinking about contracts with healthcare providers and knowing that many of them have binding arbitration provisions and things like that, I think it really is fuel for us to kind of think of what society is going to look like once we walk out of this. And I think that it's pretty clear that people where they live and people having money and people getting medical treatment and fighting about bills are just some of the most obvious areas to me. And I think it's going to be worse than it ever has been before.
That's a good point, Julia. And I think I agree. I think there is a lot of urgency to this work. And I think this, as we look at this recovery, what that means, especially to the folks that, low income folks who are getting hit twice as hard by this pandemic. So yeah, I think that as this could be an option to provide legal services or access to legal services for the population, I think that's something and that's going to be impacting folks from throughout the state, right? Central Valley, coast, everything. So,
Russia, I think maybe if you advance it to the justice gap slide, Julia, I just want to make sure, were you talking the justice gap?
Yeah. Well, I have, yes, Leah, I have health, finance, and employment, but then I also have family laws being a traditional area where the other states have included. It's quite a form-driven location, but I think, yes, the justice gap was health, finance, and employment.
Okay, great.
Yes. So I think health and finance, and quite frankly, finance is going to go with employment. I think we're going to see a need that we have never seen before in the next year.
Okay. Stephen Fleischman, I think you're next.
Thank you. I sort of look at this as kind of process of elimination. Where would I not want these programs? And I saw Arizona. I definitely, under no circumstances, would want it in criminal law. I just think the risks are too high, and there already is Gideon for criminal law. On traditional civil, I heard Her Honor's comment, and I was a little surprised by that. I think traditional civil again, requires court appearances and eventually the ability to go to trial. And I don't think we're going to get there, at least not in the beginning. In terms of immigration, when I read the public comments and the ATIL's report, I was very surprised by the amount of concern that that appears to be a group of people who are subject to a lot of fraud and the ability to be exploited. So I think for that reason, I'd be concerned about immigration. And sort of what's left is, excuse me, unlawful detainer and family law. I'm sure I'm leaving a few out. I'm not all that thrilled about starting with unlawful detainer because, again, eventually that requires a trial. And I'm not sure, at least in the beginning, we want to start with non-lawyers actually trying cases and making court appearances. And so I agree with Steve Hamilton's comment about starting with one subject and limited in scope and time. I kind of by default fall to family law, where if both sides are not represented, there's more of an even playing field, so long as there's some sort of supervision so that, to use a simple example, if a husband and wife are meeting with the LLLT or the paraprofessional or whoever it is, and one gets up and leaves the room, the other spouse couldn't say, well, hey, am I paying too much or too little? As soon as that happens, you start becoming a advocate for one side or the other. You start practicing law. But I think in a non-controversial divorce where you're just dividing assets and there can be an agreement and neither side has a significant amount of money, that may be sort of a sweet spot where we could start. But again, I agree with Steve Hamilton's comments that if we're going to propose anything, it should be limited in scope and time.
Okay. I think next up is Amos or Ira. Russia, which one? Sorry.
It will be even
No,
Amos and then Amos.
Yeah.
I'm sorry, was that me or Ira?
You, sorry.
Okay, thank you. So just following on these comments, a few things, both from at least my quick review of this data and then from my experience, I would say it's hard not to very seriously consider family law, children in custody, name changes from all this data, both because we know the large percentage of people in those case types are self-represented and because of the legal needs studies and what the other states are doing. I'm not a family law attorney, so I think it would be important to hear from people in that area who could tell us what the need is and what the types of duties that might make sense. But I think just given all this data, it seems clear that that should at least be one area that we seriously consider. I will also say that looking at this consumer debt, for the reasons Julia mentioned, I think maybe something that it is civil in nature, but there might be things where there's going to be there already is a huge need, and that already is something that a lot of consumers need help with. But those tasks and how those proceedings usually go forward, I think there may really be a space for paraprofessionals to do more than provide information, but actually help with how do you resolve this, how do you negotiate this, or what your options are, and actually help them through. So I think we should really look at consumer debt in those types of proceedings. Veterans is also on here. There is a huge need for veterans. I think that's tricky because it's federal, and so there are a lot of the federal veterans benefits and upgrades and things like that. I'm not sure if this is a state law issue or a federalism issue, so that's something I think we should consider. But I would love for us to be able to do something and create more help for veterans as well. So I think that should be on our list, especially if it's possible for us to do something with state regulations to do that. And one more things I want to add is I agree with the, what do we not want to do, or where are there real concerns? I do think immigration is one. Again, I think we might hear more about that, but I know that there is a very large concern about a very vulnerable population, that there's already a lot of fraud and people being taken advantage of, and reluctance to come forward with complaints and not enough enforcement. So I think we should, if we're thinking about that, I think we should be very careful about that area. I'd also add landlord-tenant. I'm not sure that's the area where we want to start this for some of the reasons that were mentioned. I think where the real need there is, and there is a real need, but I think it has more to do with the appearance in court, the negotiation, and representation when there is an attorney on the other side, which is the large majority of cases. And there already is a movement of sort of a civil Gideon and right to an attorney, or providing attorneys to low-income tenants, that's sort of going across the country, and it started in New York, and it's in San Francisco, and it's coming to Los Angeles. And so I don't want to undermine or undercut the need for, and there's a lot of data out there about attorneys for low-income tenants in those proceedings and even the playing field. So if we go there again, I think we should really have our eyes open and not jump right into that, but understand that there's a lot more dynamics going on in those cases. But I think with family law, children in custody, name change, consumer debt, veterans, and maybe this income maintenance, I'm not sure I understand what that is, but if that's benefits and things like that, I also think that could be a real area where there's a huge need, and there are administrative proceedings usually. So I would also include potentially income maintenance if we can have a little more understanding of what that is.
Great. Donna.
Yeah, so just I'm glad, Amos, that you talked about the areas of law the way that you did, because one of the things that jumped out at me when Stephen Fleischman was talking right before you is I was worried that he was conflating the question about what subject matter areas are appropriate versus what tasks within those subject matters might be appropriate. I think what we are asking this group to do, among many other things, is to sort of think about, where would you be willing to cross the barrier of what would otherwise be, the unauthorized practice of law in certain case types, in certain subject matters. And so I think the sort of the preliminary question that we're asking you to think through today with this rubric that Leah has walked us through is, what are the areas of law where we might be willing to breach that line of what is today the unauthorized practice of law. We'll decide another day, once we narrow down those areas and we get input from experts in those fields, how far would we be willing to go in those areas. But for now, I think really focusing on not that down the road there may be a trial in a particular case type, but rather, there may be things in a particular case type where it would be beneficial for people who currently have no access to any sort of legal services to get some help in the early phases of the particular work that the legal area that they're looking at. And then, ultimately there may still be a trial, and they may continue to be unrepresented in that trial tomorrow the way that they are today. But if they've gotten help up to a certain point, that might allow them to resolve the matter earlier, to avoid going to trial in the first place, or to at least be more prepared when they do go to trial. So I was glad, Amos, the sort of the way that you talked about those, because I think that's a really good structure for this group to be debating, sort of which are those case types in which it might make sense to push that barrier of what was previously prohibited, that we now might be willing to permit those non-lawyers to participate in.
Ira.
Thank you. I really agree with what Donna just said about thinking about what parts of what things that lawyers do that would otherwise be the unauthorized practice of law, unlawful practice of law. We can have paraprofessionals do, and I think there's a lot of them. I've even in recent years, not 30 years ago, 40 when I was a legal aid lawyer, but even in recent years, I've worked, represented low-income people in unlawful detainer, in debt collection, and even family law. And well, here, let me give an example, a couple examples. Civil cases, general civil cases, where there isn't a ton of money involved, like the limited civil jurisdiction is $25,000. We had at our law school, we had a mock trials, and two of the students who were second-year students, and this is a 4-year law school, so they had a year and a half out of 4 years of school by then, were just great at putting on a trial, and they were great at the discovery and all the other stuff we did in those mock cases. In unlawful detainer, it's true that's a rougher trial. There's a lot more going on there, I think, than in a collection trial. But there's only about a half a dozen issues that need to be negotiated when the unrepresented tenant is dealing with the lawyer for the landlord. And I think plenty of paraprofessional non-lawyers can become familiar enough and very skilled in negotiating those issues, and to the point where they ought to be allowed to represent tenants or landlords, as there are a lot of low-income landlords. They ought to be allowed to represent them in the negotiations and everything up to the actual trial. Well, we ought to open our minds up to that even, I think. One other thought is unrelated. In case, well, the thought was this. There are all kinds of grants that are being offered to help with COVID. What year is it? To help with that crisis, and I wonder if some of that money might be available for our pilot projects, for instance. Oh, and one last thing. There is going to be a ton of eviction cases starting whenever the courts open up, because all the there's lots and lots that have been filed, and they're still being filed, but the courts are closed, and then a few months after the courts reopen, there's going to be a whole lot of those cases. Okay, thanks.
Ethan Hamilton, you've had your hand up for a while.
Thank you. And I think on those unlawful detainers, I don't remember if it was 60 or 90 days, but there's a stay on the service of them. So it's going to be a little bit longer. Once the courts reopen, they have to still wait 60 or 90 days to serve the summons to even start the case. It's not unintended that the California Lawyers Association picked a family law attorney to be the representative. But that I'm not here necessarily to advocate solely with regards to family law. One of the things that my charge is going to be is I've got to reach out to the other 16 substantive sections in the California Lawyers Association. So regarding anything, so if we're dealing with unlawful detainers and that becomes a big issue for the committee or the working group, then I'm expecting to have dialogue with the real property section. So that's, I think, part of my function too, is to reach out to them. I guess what it was is this morning, as I was reviewing all my notes and thinking of things, obviously I gravitated to family law. I live in a small county, so it's easy to track statistics in. We're not watching as many. I was actually going to reach out to Dean Winnick at some point because Monterey College of Law has an institute or a law school here in San Luis Obispo County. And my thought was you could do a one-year trial program somewhere like San Luis Obispo, where it would be very easy to track with the 3 family law judicial officers how this is impacting their caseload, the case management. And instead of being that narrow about it, kind of to dovetail what Ira said, we could pick different areas to try out different ideas. And I understand there's an idea, maybe we could make it broader. We could do different parts of different areas of law. But I think it will be much more difficult to track the outcomes if you're spread out in multiple courtrooms, especially in those jurisdictions where you have defined departments. For example, San Luis Obispo, there's the civil team and there's the family law team that's separate from the civil team. There's the criminal team. And in those kind of jurisdictions, you would have to be dealing with the entire bench in order to get feedback on whether this program is being effective or not in their courtrooms. So that's the reason why I was thinking of a trial program limited by subject area matter, but also limited by geographic area. Thank you.
All right, Sharon's next. I did want to comment though, I think some of your remarks lend themselves to a discussion around metrics and assessment. And it's interesting that sort of your focal point is around court-based legal services. And I think that that's really important, and it's going to be one component, but just remember that some of the other legal areas we're talking about, and perhaps to some extent family, but certainly some of these other areas, there are transactions and sort of administrative remedies that may never show up in a courthouse, but would still be very valuable for folks to have advocacy around. So Sharon, you're up.
Yes, so right now I'm running COVID response for One Justice, and I could tell you unequivocally that employment issues are just off the charts. And the issue with that is that a lot of the law firms that we rely on for pro bono feel like they're conflicted out because of subject matter conflicts. I know educated folks who have applied for their own benefits and made some errors and did not get benefits. I think that, employment in general is an issue beyond COVID, as the study shows. And if there's a way to have paraprofessionals focus on that, on the pieces that make sense for paraprofessionals, that would be of great service.
Okay, thank you. Dana.
Sorry about that. I agree with many of the things that Amos said. And I really heard what Donna said as well. But I'm hoping that if there's a practice area that we don't choose, that we don't ignore some tasks within an unchosen practice area that might lend itself, something that's very form heavy, for example, something that where there's no opponent on the other side, perhaps. And then when we're talking about name change, if we could include gender change as well. I've helped a lot of people with gender change forms in California. They're not simple enough to not need help, but you certainly don't need a law degree. You just need the language, really. And these are things that have to be done before you can move on to the federal and get a passport in your new gender. So if we would include that. And then I'm also very curious to know why Amos's hair still looks so good when mine looks terrible.
All right, thank you for that. I got a home haircut this morning.
Well, there it is. Not fair.
All right, I think we have Carolyn up next. Oh, we can't hear you. You have to unmute yourself.
I'll get this figured out eventually. I want to apologize first. My cat needs to get fed around too, and she started to like circle the computer like a shark. So if you saw that, okay. So couple of things. I wanted to agree with Steve that some of the trial issues, some of these issues are really going to be hard to develop into a paraprofessional. And I'd love to hear Julie's take, because she's taught people in that community college level and IRA too, and how, some of this is difficult to really go through on a subject area by subject area, because the training component is so crucial, how you build in those safety nets in terms of training people. So I think that is going to make it tough to really make a substantive decision. That's one of the harder components. The other was some of these things in the Justice Gap study seemed to really relate to communication and whether people really knew there was legal help available to you. And I know Judge Yu mentioned earlier that there were people in auto crash cases who didn't think that somebody could come in and handle the amount of money that they had. And I, being a solo attorney and just communicating with my peers, there are many, many solo attorneys who will do very low level cases that you wouldn't think a contingency fee would support. But when you do enough of them, you're able to really build that in. And I don't think there's a few people at the top who can afford millions and millions of dollars of website and all this information. How does a solo, how do young people cut through and say, I can handle those kind of cases? So that Justice Gap component that I know we were going to talk about at the end of how you build that communication to people, I think that's a component too. I don't know how we deal with that today. The other thing, since we're brainstorming, is what Bonnie said, and her presentation was just completely eye-opening to me, and I learned a whole bunch. And what I've wondered for forever, especially with the conservatorship cases, and it was great to hear about those forms filling out machine, however they've streamed like that. That's wonderful. But also having helped people with domestic violence, some of these areas where people are struggling and having a hard time are where the forms are the most thicketed. And I know every box on there is discussed and gone through and perfected, but some of these things in the, where we're dealing with, those people in that middle gap, they know enough that they need to get that form. It's an issue that's a contested custody. The form may be part of the barrier to people thinking, I can't go stand in that self-help line. They're not gonna be able to help me anyway. And then lastly, I thought one of the areas too, again, apologize if I'm taking up too much time, but try and get it out at once, is somebody mentioned the lifting out of poverty concept. And again, in the Justice Gap survey, you had there, the kind of the things that people underneath the certain threshold level of poverty are really looking for. And I didn't see kind of there's sort of a thread, but I don't know if maybe there's worth a discussion of a thread where we say homelessness, disability, some of the mental health, dealing with difficult conservatorship issues. If there's a way to sort of think through how do we get that next level of person. It was really interesting. Again, I'm learning so much here. The social, social workers were used in some context, in an ability to kind of cross that UPL line. So again, I'm brainstorming. Sorry for going on and on and on, but those are kind of just some of the 4 things that I thought, might be worth a thought process.
Great. And just, you should all be able to see, I texted Russia and asked her to just start creating some notes on the screen. And please don't feel like any of this is definitive. It's just trying to capture sort of the general sense of the discussion, but feel free to add things. They should move between columns. I just wanted to start getting it down. Helen, you're up. We can't hear you. Can you guys hear Helen?
Okay, hold on. All right, so you should be able to hear me now, right?
Yeah.
Okay. So I just wanted to respond to some of the questions regarding the justice gap study and that how it may play out. So first, Amos, I think your points were extremely well taken. For income maintenance, there were questions about the earned income tax credit, the reduction or termination of state government income, and with EDD-like benefits, which many people are experiencing now, and government benefits, including food, income, disability, or housing benefits, and the denial of SSI or SSDI. So I think in terms of how some of these questions were laid out, I also do want to caution, though, when we're looking at low income, I think everyone in this group would identify a family of 4 living off of $50,000 a year would still be considered low income. So when we look at the data, I want you to focus on the fact that the 125 was really derived from those that would be eligible for legal aid services. And so when we look at that holistically, that again, when we look at how prevalent the justice gap goes up, even if you're making $75,000 a year, I don't want you to necessarily just focus it on the categories that were laid out in the justice gap for those that were low income. And my background is also in legal aid. And oftentimes these issues like eviction is a result of losing your job, losing your benefits, dealing with consumer collection debt. And so that, that's usually the last straw after dealing with many different notices. So for example, the consumer question about, I dealt with many clients that had bills that were well over 4 years old, that were sold from, cell phone companies that no longer existed, thinking they still had to pay the bill, not knowing that the statute of limitation was 4 years, and so they shouldn't be paying anymore, not to restart the clock, right? And so I do want, as this group comes together with so many different areas of expertise, to see how this plays out for an average Californian consumer who gets a bill thinking it's a collection agency saying, oh, if you don't pay this, something's gonna happen, and how that plays out for their lives in many different ways. And so that was one aspect. And then the other was in related to finance. Wasn't there one state that did something on consumer or debt collections at a max of like $20,000 or $30,000? I remember reading that report. I wasn't sure if it was Utah or if it was Arizona. But to think of it as a sandbox, if you're looking at consumer debt, which is going to skyrocket during this time as well. And then to piggyback on what Sharon Bashan said, our office also oversees all the grant funding that's going out to the legal aid organizations. And the issues right now are all government benefits in relation to unemployment income and the benefits in order to sustain the families. So that was it.
Thanks, Helen. Debbie.
Okay, I would like to go back a little bit to the civil issues. I do know of people, and like my background is just as a consumer. That's what I'm on the board for. That's my role. But I know there people are saying that there are attorneys out there that will take small dollar amount civil issues when people have actually been actually hurt. It's not easy to find those lawyers, and except maybe some sort of educational thing, or because they don't advertise as well, or their name's not. I don't know how you find them, but I do know of a lot of people who have issues who are calling multiple attorneys because it's a small dollar amount to them, to the attorney involved, but to the person who's been harmed, it's significant, and they've been harmed, and they should be able to be made whole at some point. I also think that having some civil matters, all they need is for somebody, for the other side to know that somebody else is looking out for you. That they write you a letter that says, what, you've done something to them, you need to stop it. We're gonna come after you or something, and then they'll write themselves. So sometimes it doesn't take a lot, but a lot of people don't know how to do that, and they need somebody who can do that for them, who can write that letter that says, you need to stop doing this to this person. And So I do think I would still like to see civil on there. Yeah, none of the big, certainly none of the big cases, but I do think there are some smaller cases, some lower level cases where people are harmed and they cannot get anybody to help them. It's not. It sounds like it's it's easy to do, and it really is not. And at least it's not what I've seen in my experience. And for people that I've talked to who just said, well, I just let it go, whatever. They just got away with it. I can't do anything. Nobody, I can't get anybody even to even hear what I have to say. So, but I would like to leave it on there. Like I said, it may come off, wash out at the end, but I think it needs to have a place there.
Are you talking about personal injury, Debbie?
Some of it's personal injury, some of it's civil things where one of them was a woman whose daughter was being harassed online and stalked online and by a former friend but because we had legal services, free legal services. I said, just call them and see what they'll do. So she called them, and all they did was wrote a letter to the girl who was in school on scholarship out of state and said, you need to knock it off. And then she knocked it off. And all it took was that letter, but everything else they were doing, nothing was happening. So I think that there's, so some of it's personal injury. I think there's other civil matters that aren't necessarily personal injury where people could use some help. And sometimes you just need somebody to talk to tell them this is what you do.
Okay. So Russia, maybe you can put general civil over there in the wobbler. And Elizabeth, you're up.
Thank you. So I think that one of the questions is, as the State Bar of California, we have to remember who is California, what is California comprised of? And 36% of California is now Hispanics, of around 56% is white, and then we have Asians. So when we think about what are we going to do, maybe have that on the back of our mind as well. My recommendations would be to do things that go to the core of the livelihood of people. And I'm in agreement with a lot of what everyone has said, and I'm just building upon that. And so core to the livelihood, such as family law. So that would be my recommendation. And also, wills, and then evictions. And, the Maslow's hierarchy of needs say that, someone's basic need is, besides food and water, is safety and security. And that would mean knowing where you're going to sleep at night. So, your home. And, security and safety is the domestic violence, restraining order, civil harassment, those kinds of things. So that's what I want to see. What I would maybe not put on the forefront is like the home ownership, right? That if someone doesn't buy a home this year, there's always next year. With family law, if someone, doesn't get a restraining order, there's higher consequences. That goes to, the other thing I wanted to point out is there's already a lot of federal programs out there. For example, if someone doesn't pay that debt, they can go to a bankruptcy petition preparer, and the federal district court allows people to do that for them. So same thing with if someone's denied Social Security benefits, there's those Social Security representatives that are allowed to go into administrative hearings and help them out. So we have to remember there's already help for some people. And I know that not every program is perfect, like we've said, but that's where I'm coming from. And then, let me see. And then the other thing that we have to ask ourselves is, what is the consequences of not doing something, right? So what if we choose not to do family law? What are we going to see? And so that's kind of where I'm coming from as well. And going back to like, who is California? Like someone mentioned earlier, names and gender change are important. It may not be as important in Utah or, in other states that don't allow, same-sex marriages or things like that. But again, who's California and who are we here to protect? And then the last thing I would mention is in terms of legal advice, I like to ask myself, what's the worst that can happen? If we give somebody this, this training and they go check all the boxes, they go through all the motions, they give legal advice, but it was wrong despite all the training they took, what is the worst that can happen? In the criminal case, someone loses their freedom, their liberty. So I agree, let's not do that. But that's, again, let's start thinking about what's the worst that could happen if this happens. That's all. Thank you.
Thank you. I think that was a really great sort of framing suggestions. I do want to know that you are the first person that's raised estates and trusts, kind of wills. I think most of the rest of what you talked about is somewhere on the sheet. And the other issue that maybe, Julia, you raised, but we haven't heard it again, is health. So as we go to our next couple of speakers, we've got Stephen Fleischman and Amos. I do want to ask all of you to think about estates and trusts and health. And with that, Stephen, you're up.
I just wanted to explain my prior comment about why I don't think unlawful detainer is appropriate for consideration. I think while a non-lawyer may be able to do a lot of the things that Bonnie described earlier through the self-help center, at the end of the day, if that case doesn't settle, it's going to have to be tried by somebody. And I think the consumer is going to be very disappointed when they find out I had to hire one person, now I have to hire a second person. And you then start getting into the issue of referrals by the non-attorney to the attorney and the issue of are they allowed to share fees or not. I just think that's a rat's nest that we don't want to get into, at least for a preliminary pilot program type of issue. And I feel the same way about civil and employment, that it's one thing to consult with somebody before litigation is filed on employment, but once litigation is filed, I think you have to have an actual lawyer. And to my knowledge, there is no shortage of attorneys willing to take employment cases representing employees that have been laid off, in part because there are attorney fee provisions that make it, frankly, very financially lucrative for attorneys to take those cases. I don't want to get into the pros and cons of that, but I'm not aware of people not able to find employment attorneys. Maybe Ira will tell me I'm wrong about that, but so for employment, I would list it as, pre-lawsuit counseling, maybe. But things like name and gender change, absolutely, that would be something I could get behind.
Okay, Amos.
Thank you. Sorry to go again, but I did want to also clarify, especially with Helen's comments about what was called income maintenance. I think that is different than employment and anything else that's on the chart right now. And it sounds like it really could be and should be important and considered in terms of, benefits. So unemployment benefits or disability benefits, but also it might go into finance and employment as well. So I think we should still consider income maintenance in broader than employment terms, because there may be a lot of other things that might be helpful. I want to agree with Stephen. I already mentioned that I have real hesitation about landlord-tenant. I think for a host of other reasons that weren't mentioned by Stephen, but I do think that's one that causes real concern. And also for the reasons somebody else mentioned about what's at stake, but also just the uneven bargaining when it's an attorney and a non-attorney in that context. So there was also a question about health and wills and trusts. again, we may want to hear more about health. I think one of the major issues in the health space is the consumer debt issue. It's the expense, the medical bill that you get if you go to an emergency room. They're astronomical and they cause all sorts of problems that has a domino effect. So I think that might be covered under the debt, consumer debt or debt collection, which I think is important. I'm not sure if there's other types of issues in the health space that we may also want to consider as well.
Leah, can I just jump in here? It's Erica Yu. The reason is I don't think I copied you on the email yesterday. I'm sorry, but I have to leave to teach a class at 3.
Okay.
So I wanted to just say that I agreed with what Donna and Debbie said, that even if we thought about limited civil, that somehow we should consider this. I mean, there may be in some jurisdictions attorneys who are willing to take certain cases, but in some jurisdictions there aren't. Also, there's a language access issue. I mean, sometimes people need to have that letter written, like Debbie said, but they don't know who to go to, and there's no one they feel comfortable because it's a language issue. So just because a lawyer can do something, to me, doesn't mean we shouldn't consider it as a potential task for a paraprofessional. Kind of hearkening back to the beginning when we talked about the difference between a nurse practitioner and a doctor. I agreed with what Ira said, which is that I think while there will be a little bit of a lag time, there are going to be a lot of unlawful detainer matters that are going to be there. So I do think that there might be a role for paraprofessionals and unlawful detainers in Santa Clara County. For example, the office, the Ombudsman office, it's a part of the county. They provide volunteers who will help litigants settle their cases, or at least try to settle or work out a stay of eviction and some type of payment plan. So I think it was, I'm not sure, but it might have been Amos who also said, let's think about paraprofessionals in terms of dispute resolution. I think that kind of goes along with some of what I've been thinking, which is to write that letter to resolve a civil harassment case, for example, or to negotiate with an insurance adjuster. And while there's, definitely a point about if you hire someone and you think they're going to do something, do you have to hire them again to do a trial? When we look to unbundled services, I think it is clear to the client that the person who's helping them is only helping them for a certain thing, maybe a restraining order hearing. And the client understands that if it's going to go beyond that task, they may need to hire someone else or renegotiate the contract. And I agree we should stay away from criminal because people can have a public defender. But I just wanted to think about restitution hearings, because often there's restitution hearings that are required where a defendant has to go to court to try to fight the fact that they shouldn't have to pay, the state of California, Caltrans, a ton of money because their auto accident knocked out a light post. And the public defenders in some jurisdictions won't represent people in kind of victim restitution hearings, and people are sort of floating out there at sea. So maybe there is a little space for some exploration as to whether or not there's room for a paraprofessional in a criminal setting. With that, I apologize that I have to leave early, and it's been a great conversation and a well-run meeting. So thank you, everybody. Take care. Be healthy.
Thank you. I am going to ask Helen to weigh in on employment and health to give us some more description about those categories from the Justice Gap study after Carolyn and Sharon speak. We can't hear you.
I know.
Okay.
So part of what my comment and question was going to be was on that issue. So I'll reserve that to hear from Helen on it. The other thing is, and again, I thought to chime in again with what Judge Yu and Donna and Debbie said. It does occur to me. I practice in LA County. I also practice in the Bay Area, and yeah, I'd be interested to see more of that data on the rural areas and what people felt. Now, being a tech geek and watching what's going on with COVID, the landscape of the judiciary is going in a 180 degrees on technology, where people were studying things, where we had ATELs discussing stuff. stuff that I thought would take 10 years, stuff that we've been waiting for 10 years is happening in like 3 weeks time. We have mandatory e-service. We have mediations online. We have filing remotely. And a lot of those things, you know, may very well drastically change the availability of some of these things in those rural areas. And we just don't know. We don't know if any of that stuff's going to stick. But I know right now attorneys are just either in love or they hate it. But there is a lot of stuff going on right now to change that equation that really, you know, kind of needs to be. And translations, you can find translators online. There are services that give you online, you know, kind of 1-800 number services that do translations. So there's a whole host of things that are happening that may impact some of this stuff. But I really do want to hear Ms. Hong's discussion of employment and maybe also kind of those statistics on rural areas.
Okay, before we turn to Helen, Sharon, you have your hand up.
Can I just ask, when Helen's done, can I kind of respond to what was said about the question about teaching?
Sure.
Thank you.
Hi, this is Sharon. So I wanted to make 2 points. Right now, we're really talking about critical matters. So whether it's unlawful detainers or employment or public benefits or family law, like we know that these are oftentimes life and death situations that can really transform lives. And I just want to, I guess, like footnote that we have to be careful how we message that. I know that oftentimes among certain communities and people, there's this very false notion that if you're not paying for an attorney, they're not worth it. And sometimes legal aid gets that pushback. I would not want to create a system where we're not careful about messaging and then people think there's a 2-tier system, whether that's true or not. So just if we can put that into the parking lot and think about that at some point, messaging in general. The second thing I was going to say about employment, because someone was commenting that plaintiff side attorneys will take cases for attorney's fees. Yes and no. My experience with plaintiff side attorneys is that they will take kind of like the bigger, sexier cases. They don't necessarily take the everyday cases where there's not a lot of money to be had. And that's where the help is really needed oftentimes.
Great. Helen, are you able to weigh in now with a little bit more detail about what was covered in employment? Oh, and Julia, did you want to go before Helen or after? Is going after? Okay.
Why don't I speak before, because it kind of, I was asked or was commented on how, you know, while we're thinking about these things, think of how they're taught. And so what I come at this as having gone to law school and dealt in a lot of complex civil litigation as well as administrative law, and having trained and supervised paralegals on the job, and now I've been teaching them for almost 15 years, and I've taught 15 different courses, including family law and a variety of things. But I guess to understand my perspective, since we're comparing what this may become as something similar to a nurse practitioner, then I kind of look at this as somebody who is between a paralegal and a lawyer. Because what I see training paralegals who are very good is they learn skills that you do not learn in law school. And a lot of that also comes from, because they're being taught practically and not the Socratic method, theoretically, those kinds of things. Now, I know that law school has gotten more practical since I went to law school. Nevertheless, we do a variety of things, and I just wanted to put it out there. For example, one of our most successful programs is an expungement clinic that we have, and we have brought thousands of people to the Sacramento area under attorney supervision, yes, but that's where students have learned how to expunge someone's record. We also, for the first time, we have an attorney from Voluntary Legal Services of Northern California who's teaching class on clinic on public benefits. Now, we don't have high enrollment, but it is through these type of teachings that I think, is it that thinking about the subject matters like family law. In our next meeting, if we're going to have experts come in and talk to us, what I would really like to hear from is, if you're practicing in the family law, talk about maybe being able to divide the subject matter into particular tasks that they would delegate to their paralegal. And then maybe if there's some sort of clinic or people who are doing this as outreach, and how they are supervising those workers, because that is how I envision these students will be taught, is in a very practical way. They're going to need a setting. Now, I don't know how it's going to look, but what I do know, having taught civil litigation, advanced civil litigation for paralegals, law office management, legal research and legal writing, they have to be able to do tasks. It's a very task-based thing. And so they have to know how to create documents and things like that. So when I'm thinking about what this person would start off doing, or my expectation for them would be, what are the kinds of forms and documents that they can prepare to assist the person who needs the help, leaving that the highest performance would be at the level of some part of appearing before somebody or giving advice, but just simply in the ideas of, if people could come and speak to us about what would be the types of forms, and like you call it, unbundling, and I love that term, the types of tasks that you're going to find in family law, child custody, name change, and then maybe even in consumer debt, we only unbundle it to the point of someone coming with immediate assistance, you know, to stop the threatening telephone calls or whatever happens in terms of a small portion of their debt problem. But I approach my teaching to paralegals so that they're able to perform at an entry-level position when they get hired by a law firm. But yes, they're under the supervision of an attorney. But I feel that there are ways to teach them that they could very much be people who did certain tasks quite autonomously without the supervision of an attorney. And I think those would be the kinds of tasks would be a great pilot program to see how we might create this paraprofessional career. Thank you for letting me talk.
Okay, sure. Helen, are you available?
I'm available. I'm sorry, Leah, will you tell me exactly what you want me to speak about?
You could read the detail under employment and health from the,
Sure.
Yeah, from the
for employment, the respondents were asked questions about an employer who did not pay wages or other earned benefits, denial of workers' comp, unsafe working conditions, unfair termination, denial of accommodation for disability or medical condition, denial of unemployment benefits, inadequate treatment of the workplace of a workplace grievance, and sexual harassment by a supervisor or a coworker. For health, those questions were related to billing, the inability to access or getting other problems related to health insurance, the denial of an interpreter in a medical setting, issues with debt collection or financial assistance, and payment for needed equipment, procedures, or other services.
I'm sorry, I'm getting stuck on mute. I don't know what's happening.
Oh, I'm sorry. And then the other question was about rural differentials. In the study overall, there wasn't a marked difference between rural access and urban. The method of delivery for rural tended to be over the telephone as opposed to in person. And then the third part of, there was another section of the NORC report, which actually looked at the different regions of California and where the justice gap on specific areas were a little bit higher based on region. So for example, the Central Coast actually had a higher prevalence of employment issues than in Orange County or in the Bay Area. For the Bay Area, there was a higher prevalence of health issues than in some of the other areas. And then I think my last point would be that the Justice Gap data is rich. We just gave you a very brief overview. And if we think about this group really looking at access to justice and this area filling in a need, I think you'd want to also look at what are the areas in which moderate income Californians have identified their justiciable legal issues. Where are the services that legal aid may be able to provide services, and where are those gaps in which these different pilots may help fill that void. And so that is also something that I wanted to throw out there that you may want to consider as you move forward.
Okay. I think to some extent, just looking what's on the screen, it is a nice kind of reflection of the Justice Gap study as informed by sort of the expertise of the group and the thinking of the group. I'd like to know, we don't have any hands raised. I'd like to call all of your attention to the screen to just get your take on what we have in the ins and the outs. I'm sorry, the sound is really bad on my end.
This is Debbie Manning. I have my hand raised.
Oh, I'm sorry, Debbie, I don't see it. Go ahead.
Home ownership. I know we have it as sort of being out. One of the things I thought of, and it's something I've had a couple of friends have to deal with, was elderly parents that got reverse mortgages and the family didn't know until the person passed. But the people who are now trying to see what they can do, they don't make a lot of money. They don't have enough money to hire an attorney. But I don't know if this may not be, a large enough section. But if home ownership was on that list, I'm just kind of curious what some of those issues were.
Yeah, Helen can speak to that. I think it was really interesting in terms of the Justice Gap study results. Home ownership rated higher than rental housing in terms of need. I think it got on the out list here because of Elizabeth's comment, but I don't know that there was a full discussion of it being out. Just like all of these, just some initial thinking about where to place things.
Okay, thank you.
Ira, did you have your hand up?
Yes. This is a question for Leah again. Do you think that the home ownership got so high on that list there because of the studies still had a lot of people in it that were suffering from the 2008-2009 foreclosure, which lasted well beyond 2009?
I don't know. I'm curious, Helen, do you have thoughts or insight from having looked at the data more closely than I?
Sure. So Ira, actually the questions were very specific about if you or someone in your household experienced these types of problems in the last year. And so it should have been contained for the last 12 months. Now, some of that could be residual, but we also have to remember that so many of our seniors and the population at large that have had historical home ownership assets, this may be a reflection of the senior population as well. And then to answer the question about home ownership, the questions were asked about the target of misleading or dishonest mortgage lending practices, being told by a lender that extra financial products would be needed to be purchased to get a mortgage, failing behind payments behind a mortgage or having a home go into foreclosure, and having trouble selling or buying a property.
Something just occurred to me on that. Thanks for that info. I think there's going to be a whole lot of problems for homeowners. Well, we all realize this because of the financial collapse that we're suffering from now, and then people won't be able to pay their mortgages. There's some of them there's well, anyway, we realize that, and because their tenants can't pay the rent. I'm a tenants lawyer, but still, the organizations I work with try and support the low-income tenants too.
Okay, Bonnie, I see you have your hand up.
Hi, thanks. I thought it might be helpful to just identify that self-help centers do name change. We did 6,976 name changes last year out of the roughly 1 million services. So just to get a sense, and ran a pilot project to do live chat for name change. So and think that a lot of that can be done by chat bot. So in terms of a kind of is that a lucrative thing that, or, in terms of need, I thought that might be helpful to have that information.
That is helpful. Others have thoughts on what's in and what we have listed as out, a wobbler. Should we move home ownership over to a wobbler? Should we dig into the wobblers? Do you want to move name and gender change? Thinking about the structure for the next meeting and perhaps some work in between meetings, I'm thinking that really we're going to need to do some work on the wobbler list to kind of just help move things into the in or out columns. So in addition to bringing folks back to talk to us about what's definitely in at this point, we're going to need to do some further digging on the wobblers.
Leah?
Yeah.
This is Julie Felmuth. I'm sorry. I don't know. I can't figure out how to raise my hand other than just raising my hand.
That's fine.
I don't really have any disagreement with much of what has been said so far. I don't have much disagreement about the categories that you've listed here. I just would like to make a big picture observation, and I want to be corrected if I'm wrong. According to the charter, what this working group is designed to do is come up with a proposal to permit non-lawyers, that is people who are not licensed by the state bar and who have not passed the bar exam, to practice law in certain defined areas and not under the supervision of a lawyer. They will be licensed and certified by somebody, by some regulatory entity. We haven't gotten there yet. And we also get to make recommendations regarding the scope of their practice and the types of tasks they can do. So to me, nothing really prevents us from recommending that these folks be allowed to represent their clients in court and to do other things that fall within the definition of the practice of law. And so I would, Steve Fleischman said, at some point they're going to have to hire a second person. If we made this recommendation and if it were adopted, they wouldn't have to hire a second person. And I think this is appropriate, especially if we end up recommending the educational and experience requirements that have been adopted by Washington and Utah. Look at the experience requirements of Washington and Utah. They have to have 3,000 hours or 1,500 hours of supervised professional experience in order to do what they do. Let's all remind ourselves how many hours of professional, supervised professional experience we had to have before being licensed by the state bar. 0. So I just wanted to make that general observation, and I hope I'm not wrong. If I'm wrong, somebody tell me I'm wrong.
No, you're not. You're not wrong.
Okay, thank you.
Correct. Stephen Hamilton.
I was just going to say, I would definitely leave the name and gender change on the in list if you're keeping family law there, because that would be a very easy task to teach and confirm. That's not that difficult a process, and we can ensure that that's covered, because that absolutely needs to be part of the in list, in my opinion. Thank you.
Okay. Steve, is it Steve Fleischman?
Yeah.
Okay.
Thank you. I don't want to beat a dead horse. My concern about the concept of having non-attorneys appear in court and try cases is that is a huge first step. And I don't think we should, excuse me, start with something as fundamentally, that'll fundamentally alter the legal system like that. Some of these other ones I think we can work with, but I'm not sure judges are going to like the idea of having non-attorneys picking juries, making arguments, arguing motions, etc. So while I look at the list, I would move general civil from wobbler to out, and for consumer debt and employment, I'm fine leaving those on the list if we put parentheses pre-litigation.
Okay, I do think at this point in the working group's process, it is too soon to start eliminating tasks. So I would strongly encourage we not do that at this juncture. I see Donna's hand up, and then I'd love to hear others' thoughts on these recommendations about general civil moving things between the columns. So Donna.
Yeah, I just wanted to thank Julie for taking us back to that, to the charge, because what you described is absolutely within the power of the working group to come up with a recommendation. And it may not be a contested trial, right? It may be appearing in certain motions. There are sort of a variety of things that the group may, when they discuss the tasks, may think are appropriate. And so, you may not want to use Washington as the model because of how unsubscribed the program is. But absolutely, I think that's an important thing for this group to consider, is really sort of how far are you willing to go, and how far you're willing to go to move the line of what kinds of legal services can be provided may be very different in family law, for example, than it is in unlawful detainer or consumer debt or employment. And so, each one of those categories, when you select them, ultimately will be looking at the tasks independently for each of those areas of law. And I just want to thank Julie for sort of having us remembering that is part of our charge.
Ira.
Well, as far as general civil, I mean, Stephen makes some good points. There are trials in a lot of these cases. They have a really good point about a lot of lawyers taking employment cases because there's attorney fees provisions in a lot of these employment causes of action. But still, it was pointed out, and I agree with this in my own experience, that low value cases, I'll put them, lawyers are hard to get. But my main point is this. Is it such a big change to have paraprofessionals representing people in court? I don't think it's as big as it seems at first blush. There's all kinds of administrative cases that take place in a setting that is very, very much like a civil trial, in which non-lawyers are already, and for many decades, or some decades, have been authorized to represent people. One of them is unemployment appeals before an administrative law judge. Another is if I'm recalling right, the EEOC. There are 4 or 5 other ones that exist, and have existed a long time. Now, is a judge going to like it or not like it if non-lawyers are appearing before the judge? Number one, I don't want to be flip about this, but I want to say I don't care. If that's what the judges have to do, that's what they have to do. But but aside from being flip, many judges I've seen are very good and seem to be enthusiastic in helping. Well, they're not allowed to help, but in guiding, let's say, unrepresented people who appear in their courts. And another thing, it might seem, well, no, I won't add that one. So I strongly say, look at the kinds of cases that are going to be happening. So many more of them now with COVID-19. Debt collections we're going to have all over the place. Other kinds of civil cases that result from people not having, well, there could be unemployment cases. I mean, loss of employment cases that just are not big enough for a lawyer to take on, regardless of the attorney's fees provisions. And I'm confident there's a lot of non-lawyers who, once they get the knowledge, will be very well qualified to do these cases. And plenty of lawyers are perfectly unqualified to do them, who do them these days.
Okay, Carolyn.
Okay, all right. So a couple of things. It sounds like we're going to have the general civil thing is going to stay in discussion, but a couple of things. We go back to the medical analogies. I don't think they're necessarily always good analogies, but I think trial lawyers are surgeons. And there's so many things in the civil litigation process that are absolutely, you can't fix it. It can't be fixed. And there's so many things where it's even so bad that you can't fix it that the state bar and the statutes say the only remedy you have is to sue your attorney. And they're very simple things and they're devastating. So I think if we're going to have a discussion about anybody coming into court or handling pre-litigation where there's admissions and demand letters that need to be sent, all kinds of things, we really need to think very strongly at the same time about malpractice, about bonds, and then look at the Washington example. They really have not had that many people take up these, the challenge to go the further step. So some of this is really difficult to discuss, and let's put people in buckets and not buckets. And I look forward to sounds like we're going to have this discussion about general civil. But I believe very, very firmly, that there are plenty of attorneys, and there are going to be many more attorneys, as we do see layoffs coming. And there are people who take these cases, those smaller cases, and take them with glee, and get really good results. So, if you pick up the phone and you dial 3 things on the internet and you've talked to 4 attorneys who are the top of the Google chart, each of those Google list people is spending thousands and thousands and thousands of dollars to get up there. So to find the small attorney, attorneys in this state, I think the average is $60,000 for a salary for attorneys. There are so many attorneys who do these cases, and it's just getting the public to them. And last little thing, somebody said about expungements, and what a genius thing to have somebody be helped with. In this day and age, there's so many of those pending and waiting. And although, again, I know single individual attorneys who do those for a flat rate, and they boom, boom, boom. Some of these things is just, I think, we can talk about how to get people in touch with attorneys willing to do these things. The other areas, there's plenty of areas here where we've got on these lists where these things can be structurally fixed. But anyway, I can get on a soapbox, so someone just has to wave a little time card in front of me and say, so I'm done.
Okay.
Can I interject, because I don't know how to wave my hand on Zoom either, other than to wave my hand?
Okay.
I think what she says is right. And I'm sure there's lawyers getting laid off now who are going to just be gobbling up whatever they can get. But I will say, having worked in workers' compensation, there are hearing representatives that are not lawyers. Having worked in administrative law, in addition, when you get a DUI, you get your license suspended. You can have a paralegal perform that administrative hearing with the DMV to get your license back. There are several hearings. So I'm saying the point is well taken that we have had non-lawyers in administrative law do proceedings for a very long time. Of all the wobblers, my input is, if you were dealing only with landlord tenant up to a certain amount or something, I don't see why someone couldn't do that kind of a hearing if that was the limited scenario. The only contribution I'll make about veterans is this. I've been very involved in veterans organizations for the last 20 years. And the reason that I would think that would not be part of a pilot program is that they have so many service providers, and dealing with the VA is very difficult. They have a variety of issues. The success rate, however, of the Veterans Court in criminal settings have been very good when our judges have held those proceedings specifically for veterans. But I would think that it was, at this point, I think it may be very complicated to contemplate how we would do a pilot program unless we have truly someone with veteran experience assisting us.
Okay, I see Elizabeth has her hand raised, and then I'm gonna try, if Chris, if it's okay with you, to kind of take us to the finish line on this meeting. I think we really need to,
Yeah, that works.
yeah, figure out how we're gonna move forward. So Elizabeth.
Thanks.
I just had quick comments. The first one was, what is the alternative to not having paraprofessionals in the courtroom is what we have already. We have 85% of the people representing themselves. So people ask who is, you know, that. So anyway, so that's the alternative, and that's what we're trying to fix. The other thing is that these paraprofessionals, I see them more as referral partners as well. They're not going to take on projects that are too big for themselves. They know up until where they cannot help the client anymore, where they have to refer it out to someone else who can step in and finish it off. I don't see these paraprofessionals, you know, wanting to do the trials because they would prefer to do quantity work, right? Helping more clients than, you know, being stuck on one case for, you know, 3 months doing a trial. And then as far as the education, there are paralegal associations out there. There's also our association where we have MCLE conferences during the year, and we have attorneys come out, and the attorneys will show these legal document assistants, you know, how to do the paperwork, which boxes to check, and that kind of thing. So that's one way, in addition to paralegal education programs in City College, as also like an alternative. I mean, or in addition to, or maybe supplementing. So that's all I wanted to mention. Thanks.
Okay, great, thank you. So the first thing I'm hoping to do is kind of shore up what we're calling the wobbler column. I have a question for the group, which is on home ownership. We put it in the out, I think, because of Elizabeth's earlier comment. Debbie, you raised it as a, you know, something to possibly be included. Helen provided additional information about what it is. I think many of you have flagged the general issues around housing that are going to come up sort of post-COVID. So wanting to ask the group if this one should go in the wobbler with landlord tenant, or if it's out. You can just speak and forget about raising your hand, or there's also a little reaction button on Zoom for those of you that like to use the Zoom tools.
Leah, just, you know, just from what we're seeing in Oakland right now, there's so much activity around not necessarily home ownership, but just housing insecurity and housing vulnerability, and feeding folks just trying to stay out of homelessness. That, you know, whether it's landlord tenant or housing in general, I just would want to see that somewhere in there, right? In the wobbler or somewhere section. But I just think there's such urgency with that, and that's just going to continue. So I don't know if that's necessarily home ownership. I'm kind of thinking it more of like as a housing issue, landlord tenant issue. But that's just kind of one of the things I'm seeing. So hopefully we could structure, maybe consider that somewhere.
Okay. Anybody else?
I agree.
All right. So why don't you move it over, Russia? And Ira, you've got your hand up.
there. I was surprised to see home ownership on there in the first place, but what if we were to call it foreclosure defense or foreclosure protection, something like that? Isn't that what we're most concerned with on home ownership? It may not be. I don't know.
I think it is. I think the list that Helen read off to us is a little broader than just foreclosure prevention. So let me tell you what I'm thinking in terms of this wobbler category. I'm thinking that we are going to reach out to you and ask for a couple of you to volunteer to work with us as a staff team on each of these categories as we flesh them out between now and the next meeting, because this is, if we wait till the next meeting to try to dig into all the ins and all the wobblers, the next meeting will be very, very long. So I think we've got to do some work in between and looking at some of the successful models we have for in-between working group meeting work. They usually involve teams of 2 taking on an issue. So perhaps if we have a general category called housing in the wobbler, we can then look at the full gamut of issues, and then we'll come up with sort of a format for presentation at the next meeting. Like, this was a wobbler issue, here's the pros and cons of including, and the group of 2 that we'd be working with the staff team recommends it's in or recommends it's out after researching it further. So why don't we call it housing, and then we'll make sure we're not limiting it unnecessarily at this point. Veterans issues. I think, Amos, you raised a question about that. A couple of folks have said, yes, it's really important. Some have said it may not be appropriate. 1, because it's not necessarily California law. 2, because it's, I guess, very complex. Interestingly, these are very highly rated needs for the over 125 percenters and the under 125 percenters from our Justice Gap studies, veterans issues. So
I'd be happy to take a look at that with Amos.
Okay, who was that? That was
Julia.
You've been volunteered, Amos.
That's fine.
Okay, so we'll leave it on. General civil. Now this one, there's been, I think, strong advocacy by Steve, I think, to take it off altogether, to put it in the out. We heard from Judge Yu and others, maybe to leave it on, explore it further. Stephen Hamilton, you have your hand up. Are you going to talk about that issue? Stephen Hamilton. Okay. Let's move.
Okay, is it working now?
Yes.
Okay, I think I need to switch to push to talk or something. My comment was first about the general civil. I came from a civil litigation background, before the 26 years. And so I did a lot of civil litigation. I think there is some validity to the idea that in the small cases, you're not going to get people to get representation if they're being charged a contingency fee, and that's the only way to pay it, because no lawyer is going to take a $5,000 or $6,000 case. But in terms of what their actual outcome would be if they were paying per hour for a paraprofessional on that type of small case, it's going to have the same net effect. So I think that one could be easily put in the out column and be something to be looked at in the future for expansion. With regards to, I'll jump ahead to estates and trust, I would put that as the representative of the CLA. I know how the estates and trust sections feel about that, and on behalf of the California Lawyers Association, I believe they would take the position to not include this in the initial proposal and to put that in the out category.
Okay, thank you. Others, particularly now general civil, estates and trusts.
This is Steve Fleischman. I agree on moving those 2 categories to the
out. I'm of a like mind with the.
Can I ask a procedural question? When we take votes at some point, we will. Are those going to be part of the public session or the private session?
They're public, just like
Okay.
this meeting is public also.
Okay. So, and are we is our committee gonna function under Robert's Rules of Order, or will you be more informal? How are we gonna move issues along? Are we gonna vote on things or just talk?
That's a,
I guess.
that's a great question. You can see that it's fairly informal now. I think we're probably going to need to get more formal, and we'll have to talk about that with Chris. Right now, we were slated to have the preliminary decisions around topic areas with the keyword preliminary here. To some extent, it is really important that we nail it down because of the work that we're going to then do between now and the next meeting. But I would say that there's intended to be additional opportunity to come back and revisit practice areas after today. So I'm a little bit more comfortable not having a very explicit decision-making process now, and just to get the general sense of the group, but we'll need to establish formal rules for that for the next meeting.
And I apologize if that came off brusque after I said it. I didn't mean it in a bad way. Just how are we going to move things from call to call? Thank you.
Yeah. Ira, you've got your hand up.
Well, I thought that this was General Civil was about to be moved into the outs, and I'm very much against that. I'll give another example. Some people some friends of mine were sued on it for a $7,000, $8,000 credit card debt. And I helped them, but you didn't need a lawyer to help them. I propounded a bunch of discovery, and when faced with that, this gigantic credit card company just said, okay, we give up, we'll drop the case. The fact that a trial is going to happen in the case, really, I don't think, might happen, is not critical. That's also true of family law. If they don't settle their case, there's going to be trial. I strongly favor keeping general civil in.
So why don't we do this? Why don't we keep the list of wobblers as it is? Chris, if that works for you, and we can ask for volunteers. We have 2 for veterans already. We could ask for volunteers to work with staff on the other areas in the wobbler category, or we could do that via a follow-up email. And I would suggest, I'm thinking that a great combo might be Steve Fleischman and Ira, or Stephen Hamilton and Ira on general civil, because we'll get both perspectives, and I think that's really valuable. So
this is Fleischman. I'm happy to do civil.
Okay.
I was going to say, Leah, put him on civil and put me on estates and trust, because I'll go to the trust and estates.
All right. Okay, and if others of you see a topic in the wobbler column that is a particular interest to you, we'll dig into it. We'll try to find a couple of experienced practitioners in the area, get Bonnie's take from sort of in the field on the court side, just kind of fully flesh out the relevant justice gap study data, etc.
This is Ira. I'll do general civil. I'd also like to do unlawful detainer.
Okay.
Leah?
Yes.
Hi, it's Julie Filmuth. I think it was Julia who raised an issue. I think she said she did an expungement clinic with her students.
Mm-hmm.
And to me, that's an in, and it didn't end up on the list. Expungement is a huge issue in occupational licensing right now, because a lot of occupational licensing boards automatically deny a license if you've had any kind of criminal conviction. And a lot of times these applicants don't even know that they can get their conviction expunged. So if that's a relatively form-based process, it might serve us to put it on the in category.
Okay.
Let me just tell you, I don't run that clinic. There's another professor who meets with students and they run it as a clinic. I guess what I'm saying is there are several expungement clinics in Sacramento at the universities, law schools, and community colleges. I think it's just getting it out that it exists and already there. I don't know that it needs a platform here. Just a thought.
You know, you raise victim restitution hearings, kind of noting that criminal is out, but there are these sort of ancillary or collateral proceedings. And I think expungement is part of that. And I do think counties really vary in the level of services they're able to provide to folks in these sort of ancillary criminal matters. So I would suggest if we were going to look at expungement, we kind of put it with victim restitution and have a sort of collateral criminal consequence kind of category that maybe we could look at. That would be my suggestion.
I would agree with that. This is Sharon. And actually One Justice, through its Justice Bus trips, does expungements. And, you know, we bring pro bono attorneys into rural areas and we do those. And oftentimes the paralegals do a better job than the attorneys. No surprise there.
Okay. So maybe Sharon, we can put you on that group. The bullet Russia's writing now.
Sure.
Work with us on fleshing that out.
Would be happy.
Anybody else have a burning desire to work on one of these topics? Otherwise, we'll reach out to you after the meeting to try to make sure we have 2 folks working with us on each in the wobbler category. No? Okay, anything else? Or Chris, I can turn it over to you. I think we're good. This is good work.
Yeah, thank you very much, and thanks. Thank you, everybody, part of the working group. This has been quite a meeting. I think we accomplished a lot. So I just want to thank everybody again. And I don't know if there's any final questions or comments. I think we'll move to adjourn. If that's okay with everybody. And then, yeah,
we'll reach out regarding the wobbler review and then scheduling the next meeting. I don't think, Russia, you haven't sent out a doodle poll on that, right? So we're going to schedule the June meeting. I think that's it.
Okay, everybody. Thanks, Leah. Thanks, Russia, for coordinating the meeting and keeping us on track for the notes and everything. And thanks again. Thanks everybody for participating. Go ahead.
Chris, this is Steve Fleischman. Could I ask Russia to distribute that law review article I referenced earlier about the LLLT program in Washington? I'll be happy to send it to her.
Okay, that'd be great. Yeah, thank you.
Okay.
Absolutely.
I was also going to suggest maybe next time, think about leaving the chat function open, because there's a lot of dialogue. Like when someone brought up a good point, I wanted to send them a message, or I wanted to send a message to Bonnie, but I ended up having to do an email back and forth with her. So to consider it as an option.
Sure.
Well, it's open meeting laws, Bagley-Keene Act, which is why we're not doing.
Oh, never mind.
Yeah.
I know BK.
I wanted not to do the emails either.
Yeah, I was on FlexCom during the transaction.
Although Bonnie is not technically on the group, so that's okay, actually. Yeah. I like the raised thumbs. I'm seeing people using the Zoom reaction feature. All right. Okay, I think that's it. Thank you all. Have a great rest of your day.
Thanks, everybody.
Okay,
Thank
bye.
you.
Bye.
Everybody be safe.